let's get started. I think we're, sorry, I don't know who's phone is, I'm just checking the time. It is 9:30. Thank y'all for coming. I appreciate you. Hopefully, this is the first class we taught on divorce, probate, and stuff like that. And recently, just so you know, I have seen a lot of, Carolyn, probate issues coming across. So this is a good information for y'all to have and to absorb, okay? Because it's difficult enough in this market today where you have a listing and then just come out the week before an attorney call you and say, hey, by the way, this has never been probated. You're looking at another 90 days, y'all, okay? You don't want to do that. Because it's not Bill's fault, I promise you. And he is our preferred attorney with Burgess title. So he just telling you what he needs to do in order to make sure the title is clear, okay? Before we start, I'd like to introduce Corey. Corey owns a blue and white pressure wash, True Blue, I'm sorry. I knew it's True Blue Pressure Washing Company, and he's an entrepreneur and a vet. And so right now, I know, especially with seller want to get their house ready on the market, please, you know, one thing that you, Kurt, I know a lot of buyers sacrificing a lot of stuff right now, but if you can make your curb appeal look perfect or great, at least get people in the door, please do. Pressure washing is one of those items that will get your money back. So, Corey, you want to tell them about your business a little bit?
As being said, True Blue Pressure Washing, they're probably the newest pressure washing business in the Henry County area. As she also said, biggest thing for y'all is curb appeals. I mean, how concrete, houses, fence, roofs, I'll do it all. So
What kind of turnaround time do you have usually?
right now it's wide open.
Okay.
I do
You
have a
just
full-time
started?
job, so I am a little bit limited on how much I can do each day, but right
Okay.
now it's
So if you schedule right, you should be able to get us all done in within timely manner and get your house on the market before photos and all that stuff. So go ahead.
An average house, say, 2,500, that's a large ranch, 2,200 square foot ranch.
What are you looking at, first of all? Are you looking at the driveway? You looking at the house or?
Driveway and house.
Okay,
driveway and house. I do offer package deals. On your tables, there's a price sheet. So for a $2,200 house, it's an average driveway, you're probably looking at $400. Driveway, house, keeping the walkway, front, back patio. Of course, as the house gets larger, price will go up as well.
I gotta put siding in my house first.
It's all priced per square foot, except for a few notes in there where it's linear feet. Or 2 square foot of a fence, then that'd be.
And he also stain stacks, looks like. Restore without staining. My bad.
I don't stain, but I will restore the wood to its natural look so that you can then come by, they can come back later, put a good stain on it.
So get those houses ready to rock and roll so you can get the best price for your client. Thank you, Corey. Appreciate you.
Thank you.
All right, Bill, you want to come on down? And Melissa's our branch manager here. So if y'all have any questions, please ask her. She's she just want to say hi. Some of our agents don't know her, so I just want to introduce her really quick.
You know her voice.
Yes, yes. And Bill Miller is our preferred attorney. He's with Burgess Title and Escrow. He's got office here in Dallas/Stockbridge, and also one in Phoenix Boulevard. So by the airport. So if you got closing near there, and they also do mail away closings as well. Actually, we allow that with investors. So, you know, thank you, Bill, for teaching our class today.
So for the board, it's easy to just turn this off.
So y'all can see better.
Okay.
Thank you.
All right.
All right.
I need to get a lamp for you next time.
That's okay. I'm good. I'm good.
Enjoy.
So, that light there. My name is Bill Miller. I'm a real estate attorney. I've been doing this for about 30 years. It was kind of funny when Ming had asked me to do this and sent me the course outline that was, I guess, approved through Greg and everything else on the continuing education. It was titled Estates, Divorces, Investors, and Companies Who Can Sign the Contract. So to me, that's kind of boring, and I thought I would kind of add a twist to it. And so in your first page, I've kind of got an outline of what I want to go through. And it's all about deeds, all right? And so obviously due diligence, we're gonna spend a lot of time on that because it's something that you have to do before, kind of like going to a job interview. You need to be prepared, and we're gonna spend some time on that. So instead of estates, we're doing death, all right? So keeping with the Ds. Divorce, obviously, we're gonna spend some time on that. And then the investors, the assigners, the wholesalers, they're just dumb. A lot of these folks don't know what they're doing. And it is absolutely, and this is the market right now where they're all coming out because everybody's in real estate, right? So so we're gonna spend some time going through that as well. And then I've got some bonus Ds because I've seen some things lately that have killed deals and killed closings and everything else. The double wide, I'm gonna spend just a couple minutes. I want to talk to you about that. We had a closing, it was in DeKalb County. And gets all the way through the process and couldn't close because the title wasn't retired. You wouldn't think a double wide in DeKalb County, but it was a manufactured home and the lender wouldn't allow it to close. And so that's the D. And then deeds, I want to go through a few things, just simple things on deeds, what to look for and everything else on that. So I'm going to Destin tomorrow. That's why I stuck with this D. So we're gonna push through today, and I'll be in Destin tomorrow. It'll all be good. But the first thing I want to talk about is the due diligence piece and some tools that you can use in order to save you some time in the long run. And before you go to an appointment, the first thing, I guess, GSCCA, is anybody familiar with this? Does anybody have an account and have used it? You've used it. Okay. So for those who have not used this is the clerk's website and is an invaluable tool in kind of looking at title, who's on title, who's signed for companies before. And so I want to spend a little bit of time going through this. I think it's $12 a month to sign up. It is well worth it. And so I want to spend a little time going through that with you. I want to go through the Secretary of State's website. You've got a seller who is an LLC or a corporation, right? The first thing you would want to do is probably look on the Secretary of State's website and see, are they a Georgia corporation? Are they dissolved? We get a lot of these folks that kind of goes to the dumb. They don't ever renew their LLC and it's dissolved. And then we have to go through a couple of hoops to get that done. Or they do it as an LLC and they're incorporated, or they even have the wrong name. They don't even know the name of their LLC a lot of times because they have holdings or properties or investments and they get those mixed up. And so it might be Smith Holdings and they do Smith Properties. And so if you're going to spend the time to go meet with someone and they're in an LLC, it takes just a couple of minutes. It's a simple search. We're going to go through that just to see if they're a Georgia corporation. What is their entity? Who signs on their behalf? Tax assessor and Q Public. Does anybody look at the tax assessor site before as well and the maps and so forth? But the tax assessor will give you a good indication as to how at least the assessor's office has title. Doesn't mean that that's right. Doesn't mean that there wasn't a conveyance in the last year or year and a half, and the assessor hasn't updated that. And so I want to show you kind of a little bit on that as well. And then from a probate perspective, I want to take you to a site, the Georgia Probate Records, and show you kind of how it's not every county doesn't have the probate records listed. The probate courts for every county are not on this site, but there are a lot of them. And I want to just kind of go through that with you. You can see if there's been an estate filed. You can kind of get some information on that. We're going to talk about the estate probably more than anything. There's an attorney in McDonough who does estate work. Her name is Tanika Thompson, and she's actually going to stop by and kind of give you an idea, spend about 15 minutes with you of what that process is. How long that takes, what are the costs on that a lot, and maybe procedurally what it takes to run something through probate, and whether you're doing the administration of an estate or whether you're doing mere support, and just a couple of different options you have when you have someone who is deceased on title. The number one thing you got to figure out is, you know, do you have someone who's deceased on title? Who are you dealing with? Is it an heir? Is it the sister? Is it the daughter? And all of those things kind of go into the due diligence on the front end. And that's why I think that it is so important, you know, initially to find out who your seller is, who are the players in this transaction, and who are you dealing with, because you don't want to get to the point where you are at closing, or you have it under contract, and all of a sudden it blows up. Last month I had a situation, property was out in Rockdale County, and I get the contract, we get title back, there's 4 people on title. We always look at the contract, we make notes on our file, 2 people are on the contract, we email the listing agent, we say, hey, by the way, you know, we've got 2 people on your contract, we've got 4 people on title. She says, oh, they put it into a trust. And so, you know, okay. 2 of the people were deceased. Mom had given it to the 4 siblings. 2 of the people were deceased, 2 of the siblings. Mom might have had a trust, but they never transferred it into a trust. And so and they had both passed away within a 3-year time period. And I got a buyer calling me who's closing on his house and moving into this house, and we can't close on this house because they have to go through probate. And it's, you know, had the agent spent a little time on the front end, pulled a deed, asked for a deed, asked for anything, you would have alleviated that whole process. This guy paid for appraisal. He had gone through the whole shooting match, and we're 2 weeks before closing, and it just, you know, we're waiting on an attorney to send us where they filed this trust stuff, and that really never happened, and so it was just a real nightmare. And it's one of those things, an ounce of prevention is worth a pound of cure, and that's exactly what would have happened in this scenario had they done a little work on the front end. So let me spend a few minutes on GSCCA, and that is the clerk's website. All right, and I've started this on the search page so that this is kind of where you would start. But let's say you know, you have an LLC that you're wondering if they're, you know, who signs for them. I use GS every day. I'm on there. If we have an entity and we don't know, you know, who signs for that entity or how it's set up, I'll look to see if they've sold property in Georgia and see how they've conveyed title and how that's all been set up. And so it is a great tool for you, and a couple of you I know have done that. But when you go onto this, you can pick the county that you're searching. So if you've got a listing and it's in Henry County, and you want to just kind of see, does anybody have? I'm happy to plug something in. Does anybody have something they're working with now? They're a seller and they want me to take a look at something. Anybody got anything that better? It's fine for me if y'all can see that better.
Can you see that? Yeah, I can see it.
I got one on Tower Road, but I don't know the address.
No, but you have a name of a seller you're working with to see, and I'll plug it in and I'll say, yeah.
Dennis Luck.
Dennis Luck and is
And it's
Mr.
Fulton County.
It's Fulton County. So if Mr. Luck had called you and you just said, hey, I need to, you know, one of the things you always want to ask for is, hey, you have a copy of the deed, right? Just, you know, you want to get to legal description, want to see the deed. It doesn't mean that Dennis fell in love and quit claimed it to you know, somebody else, and now Dennis is on title with Sally or something. So this will give you the most current and up-to-date information on that. But what you could do is, and I'll put on here, so we're going to look for Dennis Luck in Fulton County. So all the counties are listed here. You can scroll down. We'll pick Fulton. It goes last name first. So what we would do is put in Mr. Luck. And then less is always more when it comes to this stuff. So we'll just do Dennis, D-E-N, and then we're going to search.
Was it $12 a month?
$12 a month.
Or look at the deed if you
It's
print it
50
out.
cents,
they
yeah,
charge you
50
for
cents. That's exactly right. Okay, so,
What's his
yeah, that's
name?
right. If you're printing, I'm sorry. So if you're printing a deed out of here, it's 50 cents to do that. You could set up a credit card account or whatever with them when you set your account up. You would have to do that anyway, because they're gonna bill your $11 or $12 a month on that credit card. And if you decided you wanted to print, you could, they'll just bill that, you get a monthly statement from them. But this is an invaluable tool on the front end to do the due diligence. So we're gonna display up to 100 results, which I had put right up in that top corner. And then we've got five hits for Mr. Luck, right? And so what we'll do is we'll click on that, we'll display the details, and then this will show you so warranty deed, this is where he took title. So we can click on that and print, but that's where he took title, right? Security deed is where he's borrowed money. So you can see here that he has a loan. Now, a lot of times we'll cross-reference if it's been canceled. So it's been assigned, right, to some other lenders. There's a quit claim deed there. There's an assignment and an assignment and an assignment. So if I'm looking at this, I would want to see the deed here. You click on the, and then you view image. We can do that. So he got this from the bank, probably out of a foreclosure. Okay. You can view the image and we'll see if the image stuff, oh, it is perfect. So there's the warranty deed.
Might be a copy.
All right. What's that?
I need a copy.
So there's a copy of the deed, right? And this was bank-owned property. Special warranty deed is a limited warranty deed. It's just like banks and HUD and everybody think they're special, so they call it special instead of limited. But same type of thing there. And then you would click here. That just shows the signature page. And then this would be the security deed. So that's where he borrowed money. All right. That's got 2 people on there. Was he on title? Let's see what he got here.
I was told originally it was 3 people.
All right, well, let's say, so there's Dennis and is that Clarence? Yeah, so you're dealing with Clarence?
No, that's the person that out of state supposedly he quit claimed his part over to his son.
Okay, so we're gonna take, we can look at that and see, but if I can get,
How up to date is this?
great question. February 3rd, 2022, you see the,
Okay.
my little clicker's working there, right there. So that's the effect. Every county has a different effective date. Clayton has been really far behind. They've been about, they were about 3 months. Now they're about 30 days. But let's just check real quick while we're looking at this. There was a quit claim deed here. All right.
What date was that?
That was 2/19/15. And Clarence gave it to Dennis and Berlin. So are you dealing with those 2?
Those are the 2 people.
Hey, so far so good.
Well, I got a question for you.
Okay, hang on, let me just see what this looks like. So there's a quit claim deed there. Clarence gave it to both of them and,
I don't see no names. Where you see the name?
all right, yeah, I'm sorry.
Maybe I'm a little slow.
Yeah, I do, I go through this stuff so quick. All right, so this is Clarence,
Okay.
all right, and he just gave it to Berlin
Oh,
and to
okay.
Dennis. So this is called the grantor,
Okay.
all right, and that's called the grantee. Grantee gets the property,
The receipt.
grantor, yeah. Grantor is giving it away, and the grantor signs, right? I already see a problem with this, that's gonna, and we could spend days on this type of stuff, but y'all, all right, so far so good with the deed. Clarence giving it to Berlin and to Dennis, so that looks good. Berlin wasn't on title before this, right, until this now, because the original deed from the bank was just to Clarence and to Dennis, so, which is fine. But now he's off, she's on. But here's the problem with this deed.
It's no good.
Hey, very good. So, and I've got deeds in your file, but the problem here is they used a notary acknowledgement, okay? And so it was acknowledged by, right? And so that's fine, but you have to have two witnesses. And they didn't do two witnesses, and we see this every week, right? And so they did it here, and they didn't do it here. And if this said notary public, and we're gonna go through deeds, and I've got some in there, that's why I wanted to go through that. And this said notary public, and they signed it and sealed it, it would be fine. But because they did a notary acknowledgement, you have to have two witnesses, and one of the witnesses can be a notary. And by having an acknowledgement there, they're not witnessing the signature, they're acknowledging that they signed that. And so therein lies a problem for your closing.
Major problem because they said the father is like 80, 90 years old in New York.
Clarence?
Can't travel, Clarence.
Yeah.
And supposedly he quit claimed it so that his son and them could, but he expects to get a check at the end.
Wouldn't we all like to check? But that is so, this is pretty in-depth and pretty detailed. You can at least look at this and see, hey,
It's the reason why it's two blanks for a witness on there.
yeah, and this is sometimes I call it the Office Depot deeds, and people do this all the time, they handwrite it or whatever, and it's almost like, I'd do it for free, not to have to fix it later, If somebody would just call us and help us and say, hey, we need to get this done. If you ever have, from a listing standpoint, someone who says, hey, we need to do a deed, so-and-so's going out of the country, so-and-so's going out of town, whoever you're dealing with attorney-wise, call them and have them do it. Don't have these folks do it by themselves. The money that they try to save is going to cost them in the long run. So in your situation, if the guy's in New York, a lot of times we'll use a notary service, mobile notary service, and there would be a notary, a New York notary that goes to New York, and they go to his house, they have him sign that, they get all of his information, and then we get a corrected deed. The problem is if Clarence dies, right? And so then you've got an issue because the deed before that was not joint tenants. And we're going to go through that as well. But that's this was a great example.
You'll see it again. You will see it again.
So that's exactly what happened. So they've transferred that over, and they've got a security deed. Let me go back and just show you we're going back there. So this is where they borrowed money, and that was Clarence and Dennis.
Yeah.
Right, everybody's good there. So that's very common, right? They have the warranty deed right behind it. They borrow the money, you file the security deed. It was Bank of America. It's been assigned a couple times. Bank of America sells a lot of stuff to, it was Nation Star. Now it's Mr. Cooper. Let's see what that says. No, that's going to it's from one of the funds bought it and is servicing it. But an assignment is, that's all fine. There's nothing out of the ordinary with any of that. I just want to show you one more thing on here because you could teach a whole class on this GSCCA stuff. But the main thing that you're looking at here is we are at real estate index and the name search. Okay. And then you put the name in, last name. I personally don't use commas and put their, a little bit of their first name. But the other thing that's interesting on here is the lien search. You can do the same thing, right? So, your seller says, I didn't pay the IRS a couple of years ago, and I just don't know if anything's filed. Well, you can always email me, and we can always look at that real quick. If you feel comfortable in this and you're fairly versed in this, you can do a lien search, the same thing. We're going to pick the county again. We're going to go Fulton. We're going to use Mr. Luck again since that was easy. There we go. Fulton County, and it auto-populates. So we already got him back in there. Okay, and now we're going to do a search there.
How far do that go back? The lien
So yeah. The lien search goes to 2004. And so from a lien standpoint, and again, I don't want to get too technical on the title stuff, but the liens are 7 years unless it's federal tax liens and so forth. And then that's 10 years. But in this situation, we've got a couple of things there. Now, these could be taxes and they're paid and it's real simple. So you just don't know. I mean, it could be property taxes and it's paid and it's real simple. But so here's one. This is in 08. That's expired. All right. So that doesn't matter. Let's just see what that was. That was, you must have not liked the radio. So we're gonna go back, but it's 08. It's 7 years. It's done in 15. So it doesn't attach to the property. And then we're gonna go here. So not so lucky. This is a Georgia Department of Revenue lien. All right. And so
Yeah.
I'm gonna tell that.
GATO.
Because I do this all the time. So right there. And you had to refile all these in 2018 before that is wiped out. But so that's a Department of Revenue lien. And so we click on that real quick. Let's just see. And it's not, so they would have to cross-reference where it's canceled. Again, they renewed this. This was an old lien. That was the old lien. And then that by law, they had to renew it in 18. So, you know, this is a lot, but you just need to know. So we've got and there's Berlin again. So that's definitely our guy.
Yeah.
Right. The good news is you probably still sell the house and pay off $456 and be good. So it's not going to kill your deal. Right. It's not 100,000.
Just clearance.
What's that? Just clearance. Oh, you got clearance.
You
That's
need to
right.
hurry up. Get the thing.
I
That's
mean,
right.
it'll usually show the canceled on there,
Yeah,
correct?
great question. Yeah, so what it'll cross-reference it down here. So instead of, like, it could actually have cancellation underneath this. So right over here, it would cross-reference. So this is the original filing. Okay, this was where it was refiled. And then it would also have a cancellation cross-reference right down there. And then you would just move on. But it would also show cancellation down here probably too. There would be another block that had a cancellation. But yes, it should be cross-referenced. And then this was the original Department of Revenue. And then they refiled it in 18, which is what they had to do.
Would defaulted student loans show up on here too?
If they got a judgment against someone, and not to get too technical, but you have to be sued, right? You have to get a judgment against that person, and then you file a FIFA. And that's why these are all called FIFAs, right? And they attach to anything you own. And so if Department of Revenue knew that you had property in Fulton County and they knew Mr. Luck owned some property up in the mountains, they could go file this, you know, in Raven County or something, and it would attach to that property there as well. So they file that wherever. I could spend all day on this stuff, but from your perspective and your standpoint of a little bit of due diligence, spending some time on this, you know, even spend $12, do it for you spend a month and just kind of go through it. Look at your friends and your neighbors and see kind of what, it's a great way to learn this stuff. I mean, it really is. I mean, everything's here. It's all public record. All right. And it is an invaluable tool. But again, real estate index, that's our deeds and everything else. And then we have the lien index. You can pull plats. Okay. So you can pull the county, you can pull the plat.
Can you check what?
You want to look at the plat too?
Just real quick.
Sure. So, all right. But here's what you have to do on that. We got to go back over here. We got to get a plat looking page, right? So we go back here. We're going to go
Can I
to.
ask a dumb question?
No, there are no, ask, I want, and by the way, stop me anytime and ask me questions. This is a great opportunity when you don't have clients with you. We've always had that question when you're sitting at the table and you've always, you know, said, well, maybe I'll ask him after closing. This is it. This is the time, this is the time to do it. I mean, absolutely. Yes, ma'am.
I just want to ask, when you have a FIFA, if you don't renew it within the 7 years, do you ever have an opportunity to renew it after that time?
No, ma'am. No,
Absolutely not.
it's done. Yeah. And so you'll see folks that renew that within like at year 6. And then it revives for another 7. And I've seen it where they've done it 3 times. So I've had something where, you know, it's been over 14 years, you know, that's on the 3rd time and they have renewed it. And it's just crazy. So
What's the difference between plat and the deed book and record? What's the difference?
It's on our contracts.
So, all right, so this is the deed, okay? And this is the subdivision. Let me just show you. All right, so this is the, he's got lot 1-12, which is kind of interesting. Castle Walk subdivision, page 1. All right, but this is what we're gonna pull. We're gonna pull plat book 199, page 32, and we're gonna see just what that looks. I mean, this is just where the survey was done by the builder or the developer before they put a driveway, a house. This has nothing to do with encroachments. This has nothing to do with, where's my house sit or anything like that. This is just gonna show you kind of maybe how deep the lot is or how wide the lot is and everything else. But you can pull this plat book and page for this subdivision. But this is the deed, and then this whole subdivision has been platted and has all of these lots in it. So we'll take a look at that real quick, and then I'll move on to a couple other things because I don't want to take all of the time on this, and we certainly could. So, all right.
You didn't have to do it.
199.32 was, does everybody remember what that was? All right, so again, you gotta pick the county, so we go down to Fulton. Right, 199.
You could pay for this for just 1 month.
I'm sorry,
You can pay for this for just 1 month.
I think there's a user thing 1 month, it's like $5, but it's a $12 for the month. You could always cancel it
That's what I'm
and
saying,
then do that. I'm sorry, 199, what was the page?
32.
Thank you. Wish I had y'all here all the time when I'm trying to go back and forth with stuff. All right, view image there, and then we're gonna see. All right, so if I can make that bigger. There we go. All right, so there's final plat, Castle Walk, and we're 112, so we're gonna be right over here, right? 1.035 acres, 125 foot of frontage, and it goes back 350 some feet, right? So
I have a last question.
We
If someone
just go
needed-
ahead and get Mr. Lucky here. and close. We've got all of the.
If someone needed a copy of their survey, because people coming in and saying, there's a discrepancy, I need a survey.
Yeah,
Can
so-
they contact this company?
That did this?
Uh-huh.
Yeah, that's it. And that's what I would recommend if this company is still around, right? So that would be, because they set the pins on that. Landmark surveying is still around. So down here at the bottom, there's a phone number, right? Landmark surveying, they could just, it's always easier for them. They've got field work. They're not reinventing the wheel. Anytime you want a survey done, if you have someone who's done a survey, you can always go to a plat and see if that's the case. A lot of times, people are going to want surveys when it's a meets and bounds description. It's not a lot. This is a lot and block, right? So we're this lot in this subdivision in phase 1, but as opposed to 2 acres on the side of Jodico Road, those are the ones a lot of times people want surveys for because they really want to see kind of where everything is. But
It's great, isn't it?
yeah. Any questions on, because I've got 3 other sites I want to go to and just show you because, this stuff's very important, but if you spend the time on the front end, you're going to be, you're golden, it's just the way to go. So, yes,
I do have a question.
sure.
What's the resolve if the gentleman, the 89-year-old?
Yeah.
Has an issue that he can't be a part of confirming this? What is your process as the attorney?
So what I don't understand. Like, what would be, just give me an example of
So
what,
you said that on one point, because it wasn't notarized correctly.
it wasn't witnessed.
It wasn't
Right.
witnessed.
Well, they had a notary acknowledgement, but they didn't have the 2 witnesses.
Okay, so what's the resolve if this
A
gentleman?
corrective deed. So what we would do, I mean, assuming he's alive and he's mentally capable to sign and everything else, is we would prepare a new deed. And then we would have that executed and signed and then back to our office.
That's where the mobile notary will go to this gentleman,
Because he's in New York.
because he's in New York.
And so you'd have a New York notary
Okay.
go to that gentleman or have that gentleman, if the gentleman works in an office and there's a notary there, it's
from our standpoint, when we're analyzing something like this, they've already signed it, right? And it's not as though, you know, you always get, and we're gonna talk about it with divorce a little bit, where you get a deed from the ex-wife or the soon-to-be ex-wife, and you never saw the soon-to-be ex-wife, and you kind of, you raises a little flag, and you think, did she really sign this? Is the husband trying to get over her and everything else? In a situation like the deed, he's already signed it. We're just trying to get it right, you know? And so I'm not as concerned about the chain of custody with that deed going all the way up. I mean, that's why we have a notary. It has to be notarized by them, but you know, I could email it to him and I could say, print it off and the notary's coming. Or if he was in an office and there was notaries there, you know, I would have him sign it, have it witnessed and notarized, have him send me back his license with the original deed, and that would fix the problem. It's a little different than a divorce situation and somebody's coming off title and, you know, that's a whole nother story.
If the gentleman
That's okay.
was not available,
Yeah.
then we have to go through court.
We not available as in
Probate.
dead?
I don't wanna say that, but you know, like if that was the case. we have to go
Yeah.
through a probate situation.
Yeah, and you know, we would try to maybe go through our underwriter and see if they would allow that because of the obstacles. The number, the easiest thing is get a corrected deed, but if that's not available, maybe what are some other options? And that's really where we're working with an attorney, you know, hey, we need to come to a solution. We need to try to get this because probate's gonna take us a long time and this isn't gonna work. And, you know, I'm gonna lose my buyer and we would run it by our title underwriters and see, hey, can we get some, because the bottom line is, will the insurance company insure title, right? And that's who we go to. We write with Chicago Title, we write with First American Title. Will that company insure the title with a deed that doesn't have a witness? And so we'd ask that question to them, what else can we get? I've had a situation like that. We've done quick claims from heirs. We're gonna go through that as well. But there are some other, you know, it becomes a little more difficult. Okay, and everything else. Any more questions on GSCCA? I got three more sites I want to show you that I think are very important as well. So far, so good? All right, good. All right, $12, please. I tell you what, here's what you do. You spend the $12, next time you're in my office for a closing, I'll refund you the $12. All right, I'll refund you the $12. It's on me, 1 month of GSCCA. It's on bill.
You can also use GSCCA for your legal description.
Absolutely right.
That's the best way. And then
Absolutely.
you just save as a PDF and then
That's
you can
right.
upload it to your listing.
That's exactly right.
So you don't have to pay for it? Is that what you're saying?
Well, they're starting to get a little bit craftier with that. So when I save as a PDF, they will sometimes.
Some
do the
people
50
do that,
cents,
click
but-
it, I don't.
Yeah, with the
They
screen
snap
grab.
it and click it, yeah. So,
But they started to catch on to that because, you know, who prints anymore?
right.
Right.
All right, so that's this one. All right, so this one's pretty easy. Secretary of State. You're dealing with an LLC or a company that you know that they're going to be the seller. You are crazy not to go to this website and just check on this before you spend any time, effort, or money. So I just did Secretary of State, Georgia, right? It is the simplest thing. This is what pulls up, and you just need to go to Georgia Business Search, right? And I have this in your packet, and I meant to tell you as well. So right behind that outline is just a blank sheet of paper if y'all needed to take notes. So I've got that for you as well. But I've got all 4 of these pages on here in your packet. But you want to do starts with, okay, and then business name. Anybody have an LLC they're working with right now as a seller? Anybody?
Not as a seller, but.
Wow. Yeah, I mean, you might have thought an LLC and I'll look at it. Anybody got a,
Belcher and Sons, BLCHER,
okay, Belcher,
yes,
BEL.
CHER and Sons.
Okay, is that right? Did I get that? Belcher.
LLC.
All right, so I would just do Belcher because you don't know if it's, and here's the thing with these corporations, right? Is it Belcher ampersand Sons?
Yeah.
Belcher and Sons spelled out? They don't know a lot of times. Especially when we get these investors who are buying and they tell us what their information is. We verify all of that now. Normally, back in the day, if you're paying cash and you're an investor and you say to us, here's how I want to put title, we'll do that. You want to take title under Tom Brady? You know, we'll let you take that. I mean, it doesn't matter to us because you're the one who's going to have to go sell that down the road and you're going to have to go But now, these guys don't even know their entity, and then they call us back and say, you put the deed in the wrong name, and I'm like, that's the name you gave us. You looked at this deed when we did the closing, you know, and so they don't know, and so now we always go to double check it. So a ton of Belchers, right? And you said and Sons, there's Belcher and Sons, are they the cleaners?
No, the property trucking.
I think
Incorporated.
That's about the fifth or sixth one.
Two down.
Two down,
Two down
Belcher and
from
Sons
where-
trucking,
I don't
okay.
think that's it. It's probably.
So let me just show you, just as a,
Capital Group.
okay, let me just show you. So when you go to pull this and you find your thing, over here to the right gives you the current status, right?
It is. It's under Capital Group LLC.
Belcher and Sons,
Down somewhere, right above that.
that's it.
Yes, that's
So
it.
it's not Sons,
It's not Sons, but on the paperwork, they sign everything. It's,
see? So there's trucking, you don't think that's them, Larry?
That's one of them, but,
Right, so if he did that, he's administratively dissolved,
and then Larry is there, but DeAndre is there.
right? So that's what, this is the dumb in my presentation, right? They don't know. And then what even drives me crazy is they don't have a bank account. So then I go to cut them a check, right? And they're like, man, I don't have a bank account for that LLC. Why the hell did you set the LLC up? You know, that is the dumb. All right, so Belcher Capital Group,
Is the correct one, yes.
all right, and that's who it is. And so he's active
Yes.
and compliant. All right, so I'm gonna click on that one. And let's just see.
This is good to know. We can find the sign.
I'm sorry.
We can find the sign.
Well, we're gonna go through that. I've got something in your packet on that, but this is just, you know, who am I putting as my seller on the contract, right? You were thinking Belcher and Sons, now it's Belcher Capital. One of the things that I see a lot of, is a lot of people will put a comma and they'll do group comma LLC, and then some people won't, right? And so when you're back on GSCCA and you ran Belcher Capital, if they had a lot of transactions, you'd have some of them that had a comma and some of them that doesn't. And technically, it needs to be just like this, right? So that's who the registered agent is. That's the person for service, or somebody's gonna serve that. A lot of times, that's who you're dealing with. They're active and compliant. I mean, all you gotta do is pay the, what, $50 a year? I mean, it's pretty easy to stay active and compliant. We deal with a lot of folks who are dissolved, right? You saw back on that other screen, a lot of those were dissolved, right? They can reinstate. It's 5 years. So it's $250. You can reinstate it. If it's something that is not going to be an entity, they're never going to use it again, we can convey as a winding up and dissolution of the business, excuse me. And we can convey out of that without having it to be reinstated, but we have to do a few more things. And, you know, it's $250 either way. You're going to pay to reinstate it. If you want to keep it, you're going to pay us to kind of get it cleaned up if need be. If it's non-compliant, they just need to pay their $50 or $60 or whatever. So that's very interesting. But this is also good too, and you probably don't realize, but there's a filing history, name history that you can look at. And so you can see down here when they started this. So filing history. All right, they formed this here, annual registration, they amended it. Let's just go here and see what that downloads to there, pops it up here. And so this is what you'll get. He was the organizer, that's your same guy. He might be the sole member of this LLC. He might be the only person that's on here. Kind of jumping ahead in my dumb category, you know, LLCs, you have members of LLCs, and then you can have a manager of the LLC. All of that's controlled by the operating agreement. And so, you know, I don't know that if you're taking a listing and you're dealing with someone, you're going to want to say to them, hey, I need to see your operating agreement. The attorney's going to want that. And you could always say, hey, why don't you go ahead and send that to me and I can get it to the attorney. And then that's a great way for you to look at it without maybe questioning, hey, you know, are you really the one who can sign this type of stuff? So an LLC the operating agreement controls who the players are, who can sign and everything else. This just states that DeAndre organized that and started everything. But an operating agreement is not filed with the Secretary of State. So that's one of the benefits of an LLC is not everybody knows your business. And so we know he's in good standing. He's filed his annual registration. We've got a principal address. Does that look right? The Joe Lane Terrace and Connors?
Yeah.
Okay. So in that situation, you had a contract with DeAndre. You'd say, DeAndre, you're Belcher Capital, not Belcher and Sons, right? And he'd look at you like, damn. But it's just, and this is so easy and it is so useful when you're dealing with entities and making sure not only who's signing the entity as far as correct signature, but the actual company that's selling it, you pull the deed as well. That'd be another way to look at that and see, how that was titled. But, this would let you know if you pulled the deed and it was Belcher Capital and then you pulled Secretary of State and it's all Belcher, everything, it looks good, then you're headed in the right direction with Belcher as a seller on this transaction. Any questions on Secretary of State? All right, that's an easy one. Tax assessor, do y'all use tax assessor
Yeah.
to look at all that stuff? Q Public, are y'all familiar with the Q Public stuff? I want to just real quick, I'm not going to go through and give you an example, but you can always Google the county's website, but this is the Q Public website, and you can go by state, and then not every tax assessor uses Q Public. But by far, I find this the most useful and resourceful as far as being able to search owners, property addresses, getting a tax map and everything else. And then you do a drop down. I mean, you could do Henry County Tax Assessor and it's going to run you to the same thing. But if we come down here to Henry. Yeah, there we go. So, well, Habersham, but you pull in owner's name, location, parcel number. Sometimes when we're trying to find, there'll be addresses we get and they'll put Jonesboro and they'll put Clayton County, but there's a sliver of Jonesboro in Henry County. And so a lot of times we'll unless we know it's Heritage Ridge subdivision or something like that, but we'll look on this to see, we'll put the address in, and as you start putting the address in, it'll kind of auto-populate, and so that's a good way to just make sure you're in the right spot. And then you come up here, you can pull the tax maps as well. So that gives you great resource, your tax assessor's information. But you had asked the question earlier about how current is that. This stuff, this is not as current because this is only, everything on the tax assessor is January 1 of the year before. So this is not going to be as current as GSCCA. This, in our Mr. Luck example, this would probably still have Clarence and Dennis on there and wouldn't have Berlin because of that quitclaim deed. So this will get you kind of an idea, but it's not going to be as up to date probably as if you went in and did a GSCCA search. All right, so the last one of these due diligence resources is Georgia probate records. Does anybody use this at all? I think this is fairly new. So on the death deed for today, this is a great way if you just have questions or inquisitive. This is free. This is a free site. There's not, the only thing that is the site that is GSCCA, which has the monthly fee. But this is very easy to navigate. The problem is not every probate court is listed on here. So not every county, but you can pull. So this will give you Georgia probate records, right? And really what you're dealing with here, what you're looking for is the estates. All right, and so you'll pull, there's weapon carry and everything else. Anything the probate court does, they have here, but you have to select the county. right? And Clayton's on here, Henry's on here, Fulton is not,
Why?
DeKalb is not. I don't know. They've either elected not to be on here or be a part of this, but let's just say, let's try Fayette County and Smith. Because there's got to be some people who've had estate stuff that. All right, so Fayette, Smith, let's see what we come up with. Holy moly. All right, so so you've got a seller, or you dealing with the daughter or the sister or an heir, and they said, oh no, we've probated mama's estate, right? And a great way to do this would be to go on these probate records, if it's the county that's listed, and just verify, right? A lot of times, if it's been fairly recent, they will have that information, and you want to ask for it because we're going to ask for it. You can always double check your client as a seller and not make them feel like you're questioning them by saying the attorney's going to need it, right? Blame it on the attorney. Everybody else does. Blame it on the attorney, right? The attorney's going to need this. Why don't you go ahead and send it to me, and I'll get this over to them with the contract so they can start working on it. It's a great way to do it. You're not the bad guy. You're not questioning them, and you're just gathering the information so we can get you to the table quicker and get everything going a little smoother. So you're dealing with an heir. They said it's probated. Oh, can you give me the paperwork? Well, I'm gonna have to dig it up and find it. I don't know where it is, everything else. If it's a county that's on here, this is a great resource for your due diligence. So for instance, let's go with, these are all, see the year, it's 2011. Holy cow, there's a bunch of them. So this must be done by year. Let's go to something more recent. Let's see, because if it was a long time ago, sometimes they don't have it. Anybody know Peggy Winsmith? I can pull this one. Nobody knows it. Okay. Let's see what we got here. All right. So this is the letters testamentary, and they've got everything. So not all of this is scanned in as a PDF, but in this situation, you could pull the will. So her estate was here. It was in 2019 when she passed away. And then they've got some of the stuff scanned in.
What's letter of testament? What is that?
Well, it's in your packet. We're going to go through it. So,
Okay.
but we're going to go through that on the, so this is where they petitioned to probate the will, right? They scan probably everything in, but so that's the petition. To answer your question, the letters are what the court issues and what we need in order to convey title out of the estate. Okay, so, and we're going to go through that in so this is where they admitted the will to be probated. This is where the executor, I know I'm going through this fairly quickly, but this is just all of the procedural items they needed. There's the letters testamentary, and I have that in your packet. So in this situation, right, Peggy's deceased, and then Stacy Allison McEachern is the executor. If you're trying to sell Peggy Wynn Smith's property, I hope you're dealing with Stacy Allison McEachern, because she's the one on behalf of the estate who can sell it, right? Not the daughter, not another family member or anything else like that. So this is what we always ask for at a closing. Hey, do you have the letters testamentary? You have a copy of the will? Because we want to make sure as well that Peggy didn't leave this particular property in Fayette County that you're trying to sell to the son, right? We also want, that's called a specific bequest. So Peggy says, I leave, the guns to so-and-so, and I leave the jewelry to so-and-so, and Tom Smith gets the property in Fayette County. Well, then what we would want on a specific request is a quick claim deed from Tom as well. It's very technical. It's all you need from a contract standpoint is you would just want to make sure you're dealing with Stacy on this, because she's the one who can sign. Tom doesn't sign the contract. This is more of a title thing for us. If it's a specific request in there, from your standpoint, all you want to deal with is make sure that you've got the executor that you're dealing with, because that's the person who has been appointed by the probate court to administer the estate and can convey
and sign everything. So
Let's assume that they tell you it's probated, you go back and
I've
you're
had that,
on your probate list and you're like, okay, it's not there.
it's not
Like,
there, right?
You get to tell them, it's not showing.
Yeah,
you
and
need to
so,
pull.
but here's the other thing too, it could be probated, and I've had this in another county, right? So they own property in Fayette, but they had already retired, they live up in Raven County, and so that's why it's always good to ask them, you know, hey, has the estate been probated? Yes, it's been probated. Well, you know, we're in Fayette, did you do it in Fayette? Oh, no, he lived in Florida, he had retired, he's in Florida, we probated that down in Florida, right? Not uncommon. So we would need to get that information, right? This is the simplest thing is they died in Fayette County, the property's in Fayette County, and the estate was probated in Fayette County. Doesn't always work that way. Yes, ma'am.
Well, I didn't think you could probate in a different state.
I didn't
If
either.
you have property in that state, I thought you had to probate
Within
in
the
that
state.
state regardless of what state you live in. That's not
You can, if you lived in that state and you lived in Florida, we've had closings where we've had letters and there's been an order allowing the sale of the property in Georgia, and it was an Ohio probate. So that's, you know, there's a lot of folks that have property in other states. Tanika's gonna be here and can probably address the jurisdiction side of that, you know, but I can tell you, we've done plenty of closings and insured plenty of titles where we had an administration done in another state, and we had the probate court there authorize the sale of the property here, and we used the same authority documents, letters testamentary from Ohio. It's the same executive, right? And so usually you probate in where your primary residence was, where you were living at the time. So I don't know that they have to go in and file, you know, there's an ancillary type of jurisdiction in probate, and you can kind of go into all that. That's probably more of a Tanika question when it comes to the procedure on all this. But, you know, it's certainly, you need to find out where the estate was probated. It's not always going to be where you're selling that piece of property, because they might have lived other places and had estate stuff done in another county. So very, very common. So any questions on the Georgia probate records?
I had a question.
Sorry.
So when Stacy is signing the documents and she's selling the property, is she signing in her name, Stacy, or the estate? Of
Yeah, that's a
Peggy
great
Smith?
question. I always like to do it as the estate of Peggy Wynn Smith. And then you could do Stacy, Allison, McEachern as executive. Because when we're running title and everything, title's gonna be in Peggy Wynn Smith,
Okay.
right? Because unless they've done a deed and they've already conveyed out of the estate. That's why you always want to say, hey, do you have a copy of the last deed? Right? This was mama's property. She owned it since the 70s. You know, let me see if I can find the deed, you know. You would do it, Peggy Wynn Smith, the estate of Peggy Wynn Smith, and then Stacy Allison, executive. And so, you know, you could almost do it on the same, you know, you could do it like you would an LLC. So ABC LLC by so-and-so as member or manager, you could do the same thing, or you could just do the estate of Peggy Wynn Smith and have Stacy sign it. It's, you know, you always want to do the estate
Okay.
as the seller on that. Yes, ma'am.
Do trusts have to be probated as well? Like wills, like a living trust? Like
Okay. Yeah, so the answer, no. You know, living, that's not an estate. A trust is a separate thing. So a lot of people take title in a trust, and they take title in the trust so that if someone dies, they don't have to probate it. The trust stays very similar to like an LLC from a standpoint of, if you're the owner of the LLC with some other people, you pass away, right? You don't have to go through probate because the title is in the LLC, right? So we're not probated, and the LLC stays, you know, is still intact and still valid. So then you might have an executor sign as the member, but the conveyance would still be from the company. You know, if you think about it from a title standpoint, if it goes into A, it's got to go out of A. Goes into B, it's got to go out of B. So in this situation, you would have, it went into Peggy, it's got to go out of Peggy. It's just coming out of her from the estate. And this is the person who's signing for the estate, right? If it's in a trust, if it goes into, a lot of people do the trust where it's the street address. So if it's like the 1-2 Smith Street, you know, land trust or trust, right? It's got to come out of the 1-2 Smith.
123 Smith Trust. It needs to go in, you know, the way it came in, it needs to be conveyed out. And so a trust is not anything like that is not anything that you would probate. You know, you're probating the individual's estate and not so much anything from an LLC standpoint or only probating the individual. Any of the other entities that hold title, there's no probate on anything like that.
With a trust though, you have to have at least one of the trustees' signature. Like if the trust was selling the house,
Right.
is there a site to find out who is in that trust to see if you're dealing with?
No,
the right
It's blind.
there's not a site for everything, but no, there's not. It's, I mean, it's kind of like an LLC. A trust is an agreement that you keep, you know, it's not public record. So you would have to have the trust agreement. A trust has to be titled in a trustee. So on the 123 Smith Street Trust, it would need to read Bill Miller as trustee of the 123 Smith Street Trust, right? It's got to be titled. The trust holds the property, but you have to have the trustee in the verbiage as well. You can have successor trustees, the trustee could die, someone else is appointed. All of that is controlled by the trust agreement. Trust agreement, very similar to the operating agreement with an LLC. It's not public record. You would need to get a copy of that. I don't know what we are on breaks or anything. Y'all tell me what you I don't know if we have a break coming. Do you guys want a break? Do you want to get some? Y'all tell me when you need 5 minutes and I'll stop. We'll just keep going until you guys wave the flag. And
Usually it breaks around 11 o'clock.
okay. I just
so
didn't know. I didn't
It's
want to be,
okay.
and I didn't want to be everybody.
I'm actually taking yours online, so to see.
You're what?
I'm taking yours online. right now.
Oh, okay, okay.
Excuse me, Bill.
Yes, yes, ma'am.
So if you have an LLC, does that get probated and how does that?
No. See, the only thing that's getting probated is the individual's estate who passes away.
Right.
The LLC still holds title.
Never
So it never, I mean, you can't kill the LLC. How about that? Right? The
Even
LLC
though-
doesn't die. It can get dissolved, but it's not gonna die.
So with the LLC, you could have a single member.
You can.
So if that single member dies, then what happens?
So you're probating the estate of the single member.
You
And
still-
the LLC would sign, right? So-and-so as executor of so-and-so, sole member of the LLC. The LLC, if title went into the LLC, it's got to go out of the LLC, right? And so if you only have one member and that member is deceased, then they could probate on that sole member. Right? They would get letters, they would, yeah.
Yeah, they must, right?
They would have to probate on that sole member. And then they would convey as the executor, but your deed would still read, LLC, right? And the signature line would be LLC, and it would be by Stacy Allison McKeecher, executor of Peggy Wynn Smith, sole member, right? And so that's how you would convey out of that. But you're not, you probate the individuals, the entity itself is always going to still be conveying the title on that. From your standpoint, writing contracts, dealing with sellers and everything else, you want to do your due diligence, you find out it's an LLC, you find out that someone's deceased in that, you kind of need to treat that as though, okay, if it's a sole member, then you're going to have some estate issues. And if it's two members, then the other member, the wife might get the husband's share of that, and there's another member. And we're going to go through resolutions and everything else on LLCs and how all that's done. But I'm trying to kind of keep it fairly simple, just from a standpoint of you're signing a contract with you're getting a listing agreement, or you're signing a contract, who are your players? And if it's an LLC, great, you've looked at the Secretary of State, that's the right entity. Who are you dealing with? Is there other people involved? Ask for the operating agreement, blame it on the attorney, right? He's going to need it. You can take a look at it and see as well. So, yes, ma'am.
Okay, so the check at closing, who is that written to?
Yeah, the estate, you have to, a lot of times. So Stacy would get an estate account. She would get a tax ID number for the estate. And, we would make it to Stacy, Stacy Allison McEachern as executor of the estate of Peggy Winsmith, and she would go deposit that in the estate account.
And then I know closing has happened, but after the fact, Stacy would then disperse that based on the original will.
Exactly right. So as an executor, you're taking that fund, those funds in, right? The debts of the house have been paid, everything has been paid out of the house. And if there are proceeds of $100,000 and one of the grandkids was supposed to get 5,000, then she could take from those proceeds and pay and distribute accordingly. Unless somebody was supposed to get a specific request and Tommy was supposed to get that house, right? Then he would get all the proceeds.
If Peggy did not specify the disbursement of the will, Stacy then disperse it as she chooses.
It's what we call, it's in the remainder. So it's in just everything that's there. It's not anything specific. So it's in the remainder. And then Stacy would then disperse those proceeds.
In the estate of.
Right, it would go into the estate account, and then the estate account would write to whoever was supposed to get, if somebody getting 10,000, somebody getting 25,000. If a lot of times you'll see, it's going to be split between, my 3 kids. And so Stacy's one of the 3 kids, and then she takes it and writes a check to herself individually and her brother and sister, and then they split that a third, and a third.
If Peggy, while she was alive, quit claim added somebody to the deed, right? Stacy could not move forward without that person also signing on it.
Great question. Happens a lot. Yeah. So, and we're going to go to that on our deeds, and that's the last deed, which is the deeds. But you're right. If Peggy owns this, and she owns it with with her girlfriend, and they're childhood friend or whatever, and they're they don't have it as joint tenants, then you got to have the other owner's signature, and Peggy only has a half interest, and then the kids only have a third of a half. They only get half of what she has. So yeah, this is assuming Peggy's the only one on there. Peggy's on title with someone else. It's tenants in common. Tenants in common. And let me I might as well jump ahead on that. On your deeds, and I've got it in your folder, but if it's a tenants, if it doesn't say anything on the deed and it's 2 people holding title, it's tenants in common, right? Meaning if I pass away and I'm holding title with Ming, my estate owns half. This is the example here. And then Ming owns half. And so we're probating my half of the estate, right? And so Stacy would go to closing. She'd sign half. I'm cutting checks. I'd cut a check to my estate for half, and I'd cut a check to me for half, right? Because she's the half owner on there. On the deeds I've given you, there's a joint tenancy. So the default on deeds is tenants in common. You have to spell out joint tenants with right of survivorship. So kind of back to the due diligence, and the deeds are the very last 2 pages in that packet are the deeds. And so, and one of them has a joint tenancy as well. But if that's the case and you're dealing with someone who's deceased, you don't have an issue because it automatically goes to the other person. So if in the situation with Mr. Luck and Berlin, let's say Berlin passed and that deed was joint tenants, all we need is Berlin's death certificate. And then it automatically goes to Dennis. We don't have to worry about probate, right? You can pull that on GSCCA. If you pulled the deed and there's the joint tenancy language, it's right after their names and it says as joint tenants with right of survivorship, right? If it doesn't say that, it defaults. The default is tenants in common.
And
So
then her kids can come in and have claims, right?
whose kids?
Berlin,
No,
if it's in common.
if it's in common, you have to probate Berlin's estate. If it's joint tenants with right of survivorship,
It
it
goes
passes
in
out of probate.
Okay.
There, it does not go through probate at all. It passes, it's not in the estate.
Okay.
Berlin might have other property, you could probate other property. So when we do closings from a practical standpoint, and we have family members, we always show people the deed, and we always point out to them the joint tenancy. Because some people, if you're 2 investors right? And you're not in an LLC, you don't want joint tenants, because you put 20, I put 20 in, you put 20 in, I pass away, you don't need to get my 20, my family needs to get my 20, right? So if you're two, business type of things, you wouldn't do that, you wouldn't do joint tenants. But if you're family, and especially a husband and wife type thing, a lot of parents will do that for estate planning purposes and put their kids on as joint tenants, right? They're getting up there in age, they add one kid, and so that way, if she passes, in essence, it goes to the one kid, and the one kid knows, I'm gonna sell this, this is what mom wanted, and I'm gonna give this to the other kids, right? And that's a great way to alleviate having to go through probate and everything else. So people use that for an estate planning thing as well as joint tenants, because if it's joint tenants and someone passes away, it automatically goes to the other owner.
Does it have to be done a certain number of years prior to their passing?
No.
Okay.
And it has to be, and again, getting technical, but it has to be conveyed together. So like if I own the property, I couldn't give you a half interest and say joint tenants. If I own the property, I got to give you the property. You and I the property together as joint tenants. You can have 3 people. It doesn't have to just be 2. You can have 4 people. It's all joint tenants. Everybody's got a joint tenant interest in it, and one of the person passes away. The problem is, and from a title standpoint, you put somebody on title, you're exposing whatever judgments they might have, and so you have to be very careful, because you go put the son in on title, and he gets in a car wreck in college and gets a judgment against him, and then they file that FIFA like they did in the lien index, and you got 4 people on title, and you got to run all 4 of them, and then you realize that the son had a car accident and a judgment for $25,000. That's coming out of the sale, right? So you have to be careful of who you're putting on title. One other thing from a title standpoint of contract, 18, I get a lot of times after closing, somebody says, I want to put my daughter on title, my son on title. My first question is, are they 18, right? We had a situation in Lake Oconee, somebody was selling property, they put it in their kids were like 12 and 14. And I'm like, you gotta be kidding me, right? So you had to have a guardian ad litem appointed, because they're under 18, you're not of age to contract. You can't sign a contract at 18. You can't sign a deed. Someone has to be appointed to monitor your estate as a minor, and it is a mess. And so you never, ever want to have someone who's a minor under 18 on a contract. Man, I spent so much time on these movies. All right, any more questions on this probate? Great website, good thing to, check out if your county's on there. It's a great thing to do. I found that some of the older, if it was estates, 10 years ago or something, you might not have all of the stuff scanned in. But on stuff you're trying to do a closing for or trying to do a listing for, it's probably within the last 5-7 years, and more than likely you're going to find what you need on here if that's the case. So, all right, so far so good. We'll go back to the packet. I'm done on this. If there's any other questions on the.
So Fulton, you have to go in person, or they have
Oh,
their
it's
own
a pain.
website?
Yeah, they don't know. They don't have their own website. For us, we have our examiners go probate court and pull that stuff. That's why it's always good if you're dealing with a seller. You have this information. Can you send me the will? The letters, testament. We're going to go through a couple of the deeds here in just a second. So,
If you don't know, if this is after the question, this is a good point for you to break, please do, and the 10 minutes break.
maybe we'll do that after due diligence, because what I want to do is turn the lights on and go through some of the stuff on the package and everything else. But I really wanted to spend, this to me is, the most important. If you spend a little bit of time and really kind of see who you're dealing with and do a little bit of research, you're going to be a lot better served in the long run and be able to get everything closed out.
So should we save our probate questions for Tamika?
Well, we're going to go through deeds, and I'm going to go through the title stuff. Tanika is going to be able to give you the procedure of things, and I told her, she can come in for 15, 20 minutes, and she's a great resource. And you're going to always, at some point, you're going to run into a situation, and then you're going to have to go through probate. But I'm going to go through some of the different options. There's year support and some other stuff, and what we see from a title standpoint, what you kind of need to look at.
I feel like an FBI agent now.
You feel like a what?
FBI agent.
But
Well, I
you
didn't
know
show
what
you
the
this,
journey
I didn't
goes
show you
through,
the skip,
right?
I didn't show you the skip tracing software. that we use. Right? Because we have that too, you
Show us
know?
that too.
I mean, it's, you know, oh no, but we had somebody one time say that, you know, it was a half brother or something, and he was in Florida, and they said, oh, he's dead, and, you know. Who found him? Straight up lying to you, you know, I mean, it's just crazy how that is. All right, this is a great segue, a great time to take a break. We're done with the due diligence side. Any other questions on that, or if you think of it, we can answer them when you get back from break. If you're, you know, have something that we need to go through.
And y'all, you know, just so you know, we're real estate agents, we're not attorneys. So if you get to one that look out too much
Oh,
fear
yeah.
on it,
You
please
don't, yeah.
call Bill.
Let me tell you what I tell my staff, and this is great advice for y'all in the aspect of contracts and everything. You don't need to solve the problem. You need to recognize there might be a problem, right? It's not your job to solve it. But if you can recognize it in the beginning, and then we can get working on it, it's gonna make everybody's life a lot easier. You're not, you know, you don't need to know all this stuff. You need to know, hey, I know a little bit, and this might be a problem. And I need to at least make a phone call, send an email, and say, hey, can you take a look at this before I go, you know, take photos and do everything else. Let's spend a little time. It doesn't take us very long to kind of weed through some of this stuff and see what's there. And we're happy to do it. It makes it easier for everybody. So keep that in mind. You don't need to solve it. You just need to recognize it from a problem standpoint. All right, let's take a break.
I would say, but I want to make a suggestion. Give the listing and say coming soon in 30 days. So we got 30 days for you to
21
clear
days,
up.
ladies,
20
21 days.
Oh, it's 21 days.
That's all MLS allows you.
Okay.
Before on that.
You got 21 days to tell us if this is going to be a bona fide listing.
Right, that's funny.
You don't get it on the line.
So
She was coming to address that.
what's that?
I thought, was her name Denise?
No, she was just gonna, I just want to give her an introduction.
Okay.
She's in this area and she does probate. She does probate, and you're gonna have a situation at some point in time where you're gonna need someone to run something through probate court. And she can give you the procedure of how that is, what it costs, what the time frame is, and that's a good resource for it. So not so much from a title standpoint and a contract standpoint. I just asked her if she could swing by and maybe spend 15 minutes and answer some questions procedurally on that. Not so much title, but you know, what would you expect as a listing agent and your seller's deceased, and now you got to realize they got to go through probate, right? So what are you looking at? You
How
know?
long this deal was 6 months because of probate?
Yeah, and certain counties are different. Clayton's horrible. Clayton County's horrible from a probate standpoint. All right, we're gonna talk about divorce next. And really, on the divorce side, I don't have a lot of documents. I don't have any documents for you, but I want to just cover in the outline on divorce. And I know that's something everybody's gonna end up with as well as a listing agent. You know, the first thing you need to look at, and that's what we just talked about, is who's on title, right? It goes back to your due diligence in divorce, right? Who's on title? You know, we do closings with divorce. They come in at different times. They hate each other. One's coming in the morning. They're coming in the afternoon. One's going in the front door. One's going out the back door. We've had the police in the parking lot before. I mean, just everything you can imagine in 30 years. It all from a divorce situation. And so, and as a listing agent, you're going to get the brunt of that because you're in the middle and you're trying to figure out who's going to do this, who's going to pay closing. I'm not doing that. I'm doing, it's a nightmare. I would imagine from your standpoint, we see the tail end of it, but you're having to deal with two parties who are in the middle of that and feuding, and it is probably very difficult for y'all as listing agents to have to do that. So let's just give an example. You get a phone call from the wife. They're going to list the house. She tells you they're getting ready to, she's going through a divorce with her husband, right? First thing is, hey, I need to see a copy of the deed. Are you both on title? Just one of you on title. You go back to your due diligence. You can kind of look at the tax assessor. Easy to see if that's the case. You get versed in GSCCA, maybe pull the deed. Ask her to pull the deed, right? Or ask her to give you a copy of the deed.
But anytime that someone's giving you a copy of the deed, it's not always the most recent. And so what they have in their file might not always be the most recent, and that's why it's always good if you can get on the GSCCA, or you email me, or email, whoever you work with from an attorney standpoint, say, can you look at this real quick? Again, it takes us no time to pull that. We're happy to do it, and it saves everybody a lot of aggravation in the long run. So let's take the example, they're both on title, all right? And they're separated, and there's not a final order yet. That divorce isn't final, it's pending, right? And so that can be a little tricky a lot of times, because it's a hot market. You want to sell that house. You finally kind of got them to agree on selling the house, but they're fighting because, it's your credit card debt. Well, hell, it's your car. You're paying your car and I'm paying my credit. Well, my credit card's 10 and your car's 20, and they're still fighting. And they each are represented by counsel, which is very nice for you and for me, because they maybe, they're listening to someone else aside from the real estate agent and the real estate attorney. And so a lot of times what we've done is we've actually, they agree to sell it. They can't agree to split it, how to split it. And they don't want to lose the deal. And we have sent that money to the court, right? And so, you never want to lose the transaction, and you never want to lose a buyer. And, you might have to have that conversation with them. Look, you guys can fight all you want, but there's going to be the money. The money is the money, and let's just put it somewhere. And then you can fight after, down the road. And so that is one example, or one solution to an issue where you have spouses who are kind of agree to sell, but don't agree to a split type of thing. It's pending. Well, so the case is pending, the divorce case, we could send that to the registry of the court, right? And they would have those funds for that divorce case in that registry, and they can split. Sometimes we'd send it to, if they agree to the attorney, to one of the attorneys, they're in their escrow account, they put it in a place where a third party can hold it, close the transaction, and fight about the money after. Right, that's exactly right. Don't lose the deal, right? And so that's a scenario that we'll see, not a ton of times, but it happens, and you'll be in the middle of it at some point in time. The tricky thing is when you get the phone call from the wife, she's ready to sell the house, and it's only the husband on title, or the soon-to-be ex-husband, right? And so really, you can't deal with the spouse because she's not the one on title, right? You've got to talk to the one and get the listing agreement and everything signed by whoever's on title. She doesn't mean she doesn't have an equitable interest. It doesn't mean, Eddie Murphy, she gets half, it doesn't mean she's not getting anything from that. But from a title standpoint and a legality standpoint, if he's the one or she's the one, if it's only one of them, that's who you need to be dealing with. It doesn't mean that, she's not going to have a say maybe in some of this stuff, but, he's the one signing, or she's the one signing and closing, not both of them. As a closing attorney, from a practical standpoint, I feel a lot more comfortable when they're both on title and they're going through divorce, because everything's listed on that HUD, they're signing off on it, right? And so, I've had situations where, it's an amicable situation, but they're still kind of fighting over it. And I put them in a room and say, all right, you hash it out. You tell us if we're paying this credit card and this credit card. We would show a line item in a situation like that. If it's two people on title, we would show a line item for each person as to what they got for proceeds, right? Because, it's that settlement statement's a receipt of the transaction. And so, the husband might be getting $25,000, the wife might be getting $40,000. We'd have the credit card debt on there, we'd have the car, we cut everything, have it all listed on there, and they would sign off on it. In that situation, they've agreed at how to split that money. A lot of times when you're sending that money in the court, one person is making the stink about it because they don't need the money and know that the other one does need the money and they ain't gonna get it, right? So they're just playing games because they know, well, hell, we'll send it to the court. It might take 6 months. I don't need that 25,000 this month, but I know she needs that 40, or vice versa. And so, a lot of times the games are played like that, because if it goes into escrow, it's gonna sit there until you can agree on it. Not to mention, you're gonna run up the attorney fees from a divorce standpoint as you fight back and forth on that. Yes, ma'am.
I had a situation where the owner of the house was the only one on the title, but they
Okay.
were going through a divorce.
Uh-huh.
And his attorney, they both have their own attorney, and his attorney advised him to have her on the listing process. So she had to sign as well, and it was a fight back and forth because she was giving him a hard time. But either way, she had to be on the listing paperwork, and she got half of the money.
Right. Well, and that's fine. But technically, if he's the only one on there, you know, I mean, it's kind of one of those things where it can't hurt, right? Have her on. I mean, if she's available and she wants to be on there and you know it's going to be a fight and she's involved and you're, you know, she's the one that called you and you realize he's the only one on title, right? You know, have them both on there, because if a situation like that, we're probably going to have her sign a quick claim deed at closing when she gets her money. And so from a practical standpoint, if the husband's only on title and the wife's getting money and there's, you know, we tell, when she comes to get her check, she's signing a quick claim deed, releasing any interest in that property, right? And that way it's kind of belt and suspenders, you know, those bridges ain't coming down and she ain't coming back to say that,
So
you know,
she's
she
not
owns.
I'm sorry, she's not on a deed in title, she's still signing quick claims to protect any potential.
You would not, to protect any claim she might come in the future and say, well, I didn't get all my money. I want, you know, this thing, it's a quick claim deed and it's in your folder as well. Quick claim deed just means, look, yeah, I release any interest I have. I don't, you know, whether I have interest or don't have interest, you know, I'm just releasing any interest I quit claim and give you any interest that I have in this property. We use that with heirs all the time and it's in your folder and I'll show that to you. But you get quick claim deeds from folks, you know, if someone thinks they have an interest, you get a quick claim so that they release their interest and they say, I don't have any interest in that. It's in a divorce situation, you know, that's a great practice from a title standpoint. If there's if one person's on title and it's contentious and they're kind of going back and forth and the wife's getting money at closing, we've had plenty of exes, you know, spouse, husband or wife come in to get a check after closing. They approve the HUD, they see what their money is, they don't want to be there, and they'll come in and get their check and we'll have them sign a quick claim deed, even though they weren't part of the transaction from a standpoint of having to sign. A good divorce attorney would look at title if a house is being sold and they would file a les pendens, okay? And I don't know if y'all are familiar with that, but a les pendens is a reference in the real estate records that there is a suit and the property is involved in that. So not to get too technical, but your divorces are filed, you know, on the civil side of things, not in the real estate side of things, they're filed in Superior Court. And so, you know, a good divorce attorney would file a les pendens in the real estate records so that when someone's examining title, they'll realize that there is a divorce pending or there is a spouse that has a claim on that property. And that would have been, we picked that up in the, all goes back to your due diligence, in the GSCCA, there's a les pendens and you would see that under the liens, not under the deed, but under the liens, you would see a les pendens. And that puts everyone on notice that there is a dispute, that property is part of that dispute. And it usually has the same style as the divorce. John Doe versus Jane Doe, you know, defendant and plaintiff. And that we picked that up. And then you have to have a release of the les pendens in order to do the closing. And that gets the spouse involved and everything if they weren't already involved. So, you know, I think from a divorce standpoint, y'all have the brunt of that more so than we do from the closing standpoint. And a lot of times when we're dealing with agents who are in the middle of that, we're in communication with them in that process. We're talking to their divorce attorney, you know, but it all goes back to who's on the title. That's really who's signing your listing agreement and your contract. And it can't hurt to have the spouse who he probably has an interest, equitable type of interest in that, but it's not necessarily a legal interest, is not on title per se, but is gonna get some money from the sale of that. And so it can't hurt to have her, on there as well, even though she wouldn't necessarily be on the settlement statement. She's not gonna, be on all part of that.
So in representing buyers then, if I
Right.
happen to hear, I'm representing buyer, and I happen to hear that, oh, they're getting a divorce, it's that, agents talk, ooh, go to him with that, like that kind of thing. Should I ask then at closing to protect the interest of my buyers that whoever the other person is, sign the quick claim? Is that something responsible that the buyer's agent should
I
do?
think that's a good question. I think from your buyer's perspective, they're gonna get an owner's title insurance policy, and it's gonna alleviate anything that you need to worry about from that standpoint. A lot of times, if there's money, you would see, if you're representing the buyer, you would see on the HUD where the spouses got their money. That would give me a comfort level, right? Everybody's kind of agreed on it. They signed off on it, even if she's not signing or he's not signing, but you see a check going to the other person. Most attorneys are gonna have them sign that quick claim deed as well. But your buyer has title insurance, and so any claim that an ex-spouse may have, against the property or ownership or anything else would be covered under that title insurance policy. So I think you could, if you knew the attorney, you say, hey, you get a quick claim, but it's not anything you want to say at the table. She's crazy. You get a quick claim from her. He's a nut. Maybe an email ahead of time. Hey, we've been at the house and this thing's, it's going sideways fast. Everything good. And just to kind of get, because you wouldn't represent the buyer, know how title is and really what's all there. You really would. Yes, ma'am.
If there was no mention of a divorce when the listing occurred,
Yeah.
only the wife is on everything, she
Yeah.
sells the home.
Right.
And then while they're under contract,
Yeah.
it comes up.
Or you don't know it. We run title
Mhm.
and we see this less pending,
Right.
and,
Puts a halt to everything.
yeah, well, not necessarily a halt, but we're gonna have to make some phone calls and figure out kind of what's we need to see. So it goes back, has there been a final order? Is it still pending, right? I mean, there might have been divorce, there's a final order. We had a closing earlier this year, and there was a final order from like 2010 that when the husband sold the house, the wife got X whatever amount of money. And sure enough, he sold the house this year and she got some money from a settlement agreement and a final order in 2010. So, I mean, some of that stuff's kind of hard to find, and usually the person who's getting the money realizes the house is for sale and calls you as the agent when the sign's in the yard or the realtor.com listing shows up and said, damn, that's our house. And then they start making phone calls.
I had a situation, the couple was divorcing. And it was not amicable. The husband's trying to give me the listing, the wife won't even speak to me. It didn't matter because he got a judgment. The wife abandoned the marriage 5 or 6, 7 years prior. So he was awarded the house. She wasn't. She kept the insurance policy though. FD. What happened is when he got ready to sell it, the mortgage company would not recognize the judge's order and still needed her signature. And she moved to Florida and never returned a phone call.
Yeah.
House went into foreclosure. I couldn't sell it. And he said he's not going to pay on something where eventually they're going to send her a check or whatever.
Right.
So what should I have done I'm thinking he probably should have got, his attorney should have asked the judge to make her sign a quick claim since the judge was giving him the house, correct?
Yes, and so in some orders, final orders, the judge or the language in the order will state that title is vested, and it has kind of quick claim language in the order. And so the title companies will rely on a judge's order that basically divests one of the spouses of title. And we would take the order and file it in the real estate records with a reference to show, because otherwise you have a missing interest, right? You got the 2 on title. It's kind of like back our LLC. If it goes into the LLC, it's got to come out, right? You got 2 in, you got to have 2 going out. You need to figure out where that other person is. You could file the final order. It's kind of very technical, but yeah, that if it was written right to divest, where it said,
What happened? The lender would have had to.
Well, yeah, I'm a little
It's not
confused
the
on the lender stuff though, because it sounds like was the loan in her name and the property was in his or
Both names.
both names? Yeah. So he didn't want her to get any proceeds, is that? Yeah,
Because she wasn't supposed to.
she wasn't supposed to. Yeah, I would have probably, I don't know how old the divorce was, but you could reopen that case and have an order from the judge. I mean, a court can order the reforming of a deed, the court can order divesting of property, you know, all kinds of stuff. There's people that do this fraudulent stuff and file quitclaim deeds and you have to go in and reform a deed and the court will invalidate the deed and void it in the real estate records and everything else. So, you know, it probably depends on what was the proceeds, right? It's a money thing and how much were they gonna get and, you know, everything else. But yes, you can get the court involved and you can do all of that. If push comes to shove, you know, and if the order was written good and it's divesting, you might be able to do that just by filing the order, but we'd have to look at that and see how all that was written from.
Can I ask a question?
Yes, ma'am.
You got a couple, they living together before they got married. She buys a house in her name.
Yeah.
They get married like 2 years after that, you know, but they were living together when she bought the house, but she only bought it in her name because he couldn't get it in his credit.
Yeah.
Okay, and then they got a divorce. But in the divorce decree, it never said anything about him getting any proceeds.
Right. So I'm not a divorce attorney,
Thank God.
but I did stay at a Holiday Inn Express last night. So my 2 cents on that would be, they bought that, she bought it before they were married. Doesn't matter that they lived together.
Right.
So it wasn't a marital asset
Okay, that's
because they bought it, you know, she was living with him, but they weren't married.
right. Okay.
So that would be my 2 cents on that. And that's why he would probably not have any claim to it,
Right.
as opposed to something that was a marital asset that they bought, you know,
Gotcha.
even though it was in her name.
So in working with divorces, is it better to do it when it's pending or when it's
You
final?
don't have the choice. Right? I mean, you don't.
Well, but some of that, you know, the one, right now, I'm currently working with clients, she wants to wait until it's final,
Right.
he's ready to go, and
Yeah.
I'm like. what
Yeah.
the
So
fuck?
the solution would be, hey, we can do this if y'all are, again,
And put it into escrow.
right? Yeah, I mean, I've held it before, you know, I don't like to hold it for a long period of time, but we've held it until, especially if they have attorneys that represent, they're not pro se. Pro se means you're doing it by yourself,
Mhm.
right? And so if they have attorneys that represent them, you know, and you know, we're on the phone with the attorneys and look, we're 30 days out on this thing, can you hold this for 30 days and we'll have this, you know, and so we'll do that. If it's really bad and they've got the court, you know, we'll give it to the registry of the court and let them kind of fight it out and do that. It's really becomes a game of who needs the money, who doesn't, and slowing it down and holding it up and everything else. But from your perspective, as the listing or as the you know, as listing agent on that, it's a matter of, you know, if you can, who's on title, how many people, you know, 1 or 2, and if you can get them to agree and you can go ahead and close it, you're probably better served getting it closed. But you're going to be the judge of that because you know how the husband's acting, how the wife's acting, and kind of what's going on with that. And the same thing, the husband might need the money and wants to sell it. And the wife's like, you know what, I'm living in it.
Mhm.
I don't want to sell it, and you're paying it, right? He's paying the mortgage, so why do I want to sell it? I mean, it goes the same thing. Happens all the time. You know, that guy's like, I need to get another house. That loan is in my name. I can't go buy another house. I'm in an apartment. You're living in the house, and I'm paying for it. And she's like, I don't want to sell it. You know?
Did he cheat? He said, did he cheat? There you go. We're even.
What's they all saying? It's cheaper to keep it.
Yes, always.
Come to the divorce, go through counseling, whatever, they have to pay for the release, right?
If they decided they weren't,
They weren't gonna go through with it, they have to pay for a release,
they're-
they just kind of like put a halt to it and that's been this.
yeah, it would all be cleared up at closing. So we would, you know, we would
Okay.
file that at closing and everything else. There's not a huge,
And it's a fee that they will pay to do that.
well, it's just the recording fees are $25 for each document at the courthouse.
Okay.
That's a pretty simple process, not anything you would need to, I mean, you got them happy and they're ready to sign and go through everything, then, you know, canceling the less pendants on a divorce is easy. That's not a, you know, not an issue, so.
I had like 6 times, like, I'm getting a divorce, or we worked it out, I'm getting a
Yeah.
divorce, and we worked it out.
Ain't love grand. All right, so Tanika's here, and I want to, any more questions from a divorce standpoint?
If it is final, who has to sign? If that's written in the decree.
Yeah, so it might be that the wife's awarded something. You know, the good thing about it being final is you know where the money's going, right? And who's having to do what, and it's not kind of in limbo, as opposed to something that's still being worked out and pending. So you're gonna want the final order. We're gonna want the final order to see where the money's going. And it doesn't mean they're not, they still hate, they probably still hate each other, and they're really not happy with the result of somebody getting more than the other one or paying off something else. But a final order is a court order, and that's gonna be a lot better from a divorce standpoint than a pending divorce and maybe having to throw money into escrow and everything else. All right, so that's the other D. You gotta see my outline, I really did good on this. It's all Ds, okay? And of course, for the estate stuff, it's death, right? And so I've got for them, executors deeds, administrators deeds, and everything from a title standpoint. And I thought it might be good from a procedural standpoint. They have a listing, and they realize someone's deceased, and there's gonna need to be probate, or there's gonna need to be a year's support. And I've got copies of all that, but maybe I thought if you could spend 15 minutes, Tanika. This is Tanika Thompson Mungo, and she is a probate attorney. I'll let her go through all that in Henry County. And we refer a lot of that. We don't, you know, do what you do, right? And so we do real estate closings, and everybody does kind of their own has their own niche. And so you're gonna run into a situation. And I wanted Tanika just to give you procedurally, you know, is this a 30, and I know it probably depends like on the county, Clayton's horrible, but procedurally, what are some of the options? I'm gonna go through in your folder, we've got some paperwork on what it looks like from a real estate standpoint, but I wanted her maybe to spend 15 or so minutes to go through that with you procedure wise. They got a ton of questions, so they said, can we wait till Tanika's here? And they've got it zoomed in, so there's folks on Zoom as well. I'm going to answer a couple of emails. I'm going to let you kind of have at it from the estate stuff. You're going to get an estate issue. Inevitable. If you haven't had it, you're going to get it. So I'll let Tanika have it for a minute. I'm going to answer some emails, and I'll be back, and she'll give you 15 minutes on that, and then we'll go through the deeds and everything else.
Wait for that last word. All right. Good morning, everyone. My name is Tanika Thompson Mungo. I'm the owner of the Thompson Mungo firm. We are located here in McDonough, Georgia, at 390 Racetrack Road. I do have business cards I can hand to everyone just to make sure you all have my contact information. And with my firm, we help families and individuals plan for and protect their legacies. So we assist clients with not only the probate process, we also help them with their estate planning to avoid some of the pitfalls that can occur during the probate process. Now, I do work with quite a bit of realtors with their clients who may encounter estate issues with properties. And it's typically when there's a family member that owns property and they're now trying to either sell it and they've been paying the taxes for forever, and they're thinking that it automatically transfers to them or something to that extent. At that point in time, if you do recognize that there is an estate issue, it's just a good idea to just contact someone to see, okay, what do we need to do moving forward from here? Now, there are different options depending on the dynamics of the family. That plays such a huge part in it as to whether or not you can go one route versus another. So if all the parties or the heirs to the estate are living, they have good relationships and they agree, it can be such a smooth process. However, if you have a family that has some very challenging dynamics, I'll term it that way, it can create a little bit more of a challenge, but there's always a way to overcome that. So depending on what is going on, you can do certain procedures or at least file certain pleadings that will go through the court process. It could take 5 months, 4 months. That would be, say, for example, a petition declaring no administration is necessary. Those are really quick and easy, but it is also dependent on the county. As Bill just mentioned, Clayton County can be a bit of a challenge, because even I did that for one of my clients in DeKalb, and it literally took Clayton County 3 months to report it. Which it's like, it makes no sense, and my client was waiting for his closing. So there are certain obstacles that we can face, but it's typically based on the waiting periods and the delays caused within the courts. Are there any questions that I can answer specifically that y'all had earlier? Yes, ma'am.
I have a question. I didn't have a question earlier, but, okay, from what your standpoint, is this before or after someone has passed away?
This is typically after. So it's if they're on title, and it can happen if, say, for example, the property was jointly held and it defaulted to tenants in common, then at that point, you will have to go through the probate process to transfer title to the intended beneficiary, if there's a will, or to the heirs at law if there is no will.
Okay, so, I know someone that, their property in New County,
Yes, ma'am.
and only one person, and that's the person that passed away. But they were gonna sell the property last year, they didn't sell it, and then they passed away this year.
The heir passed away?
The person is on
Oh,
title,
okay.
the person owns the property. Okay, so, but I know that they're living siblings,
Mhm.
and there's 2 children,
Okay, so the children would be the heir, was there a spouse?
no spouse.
Okay, so then the 2 children would need to probate her estate or his estate to be able to sell that property. They won't be able to just sell it.
So they can call you.
Absolutely. And provided if they have a great relationship.
They do, they live together.
Oh, perfect. So then that makes it a lot easier to where we can either, if we have to do a full probate, we can grant powers. So that way you won't have to petition the court again
Okay.
after you get powers to then sell. I'm sorry?
There's multiple properties.
Oh, yeah. Then they're probably gonna need to do a full probate. Because ordinarily, if you just have a pretty small estate where it's like one property, I'd advise do no administration necessary and just move along. Because it keeps it really simple. You don't have to do any reporting. You don't have to do any of the typical requirements with a full administration, and it keeps it really clean.
What do you call that?
Full administration.
No administration necessary. And that's if it's just a very simple estate where it's literally maybe one property. But the catch to that is everybody has to agree, because we have to have everything signed and executed prior to filing.
But that's from the siblings then.
Yes.
Okay.
However, if there are multiple properties and other assets and things of that nature, I would encourage doing a full probate where someone is getting letters, but I would encourage waiving the requirement to have to petition for leave to sell.
Okay. Well, I'm gonna just have them call you.
That works good.
Okay. I have a situation where I have a deed with joint tenancy,
Mhm.
right? With survivorship.
Mhm.
One died.
Mhm.
He was married with children.
Mhm.
The wife now wants to sell the house.
Okay.
The other owner is still alive.
Well,
What does the wife is entitled?
it was joint tenants with rights of survivorship with someone that was not
The wife.
then that other person that is jointly listed on that deed is now the full owner of that property.
Okay, so he will have to sell the house, and if he wants to give something to
It would
the
be
wife,
very gratuitous.
it's up to him.
Yes. It'll be quite gratuitous, because at that point, she's not entitled to anything because it passes outside of probate. So there are a couple things that person will need to do though. But, you know, when you have somebody like Bill, they clean it all up for you. It looks really pretty. Yes, ma'am.
Are your services paid for upfront or at closing? Is it a set fee, is it percentage?
Well, that is an excellent question. It is actually dependent on the circumstances. Mostly I do require a retainer, but for certain matters, I will actually do it as a flat fee. So say, for example, with the petition declaring no administration, it's so straightforward and I already have my processes in place and there's no going back and forth with people. So that's a flat fee because I know what I will need to do. However, probate itself can be such an unexpected adventure, as I like to call it, because you don't know what you will encounter. So most times I do assist clients on an hourly basis. And sometimes I have accommodated clients by allowing them to pay out of settlement proceeds. But that's if I know for sure, all right, if we're doing this petition declaring no administration necessary, they're gonna close in the next 4 months. I'll work with it that way. However, I've made that mistake before and that probate took about 2 years. And it's just not worth it for me at that point in time. For the headache of having to locate heirs and do all of that, it's too much. And my time is not compensated appropriately. So most instances, it's hourly.
And I was telling him earlier, the longest that I had under contract, the probate issue was like 6 months,
Mhm.
right? The buyers, as they're getting concerned about their loan and all of that, are those agents reaching out to you as well? Are you talking to them or you're only talking to your seller side?
I mostly communicate with my client,
Okay,
unless my client has directed that they would like for me to disclose information regarding the estate to someone else. Otherwise, I keep my mouth shut. Because my duty is to my client. Yes, ma'am.
I have a question, kind of piggybacking off of her. So my in-laws, my father-in-law died in January, right? Thank you. The home was just solely in his name. He's married. And so as far as with the spouse, she's of course still paying on the mortgage, but she wants to sell it at some point. So would that be a case where the new administration necessary will be done? As far as getting it into her name?
I would encourage her to go a different route, to be quite honest.
Okay.
I would encourage her to do a petition for your support.
Petition
For your support to have that home set aside solely as her own. And that way she would not have to be responsible for the taxes for a whole year. There are so many other benefits with other kinds of petitions.
Okay.
So in that particular circumstance, because I take it they had children?
Yeah, they have 3 children. There is a will, and he did leave her as executive of the will, but he did not mention the house in the will.
Okay, yeah, I would encourage that route because it sets it aside solely for her. And then the remainder of the estate will be divided amongst the heirs. But it gives her the opportunity to have that property solely as her own, and especially if she has minors. Oh God, that's another nightmare when you're dealing with an estate with minors. So it really and truly is dependent on the facts of each person's circumstances to make a recommendation as to which petition to use versus another.
Okay. And this is something that you would file with the court? Okay.
Yes, ma'am.
I got a
Thank you.
situation,
No problem.
I got a situation where the wife died, husband and wife. They have 2 kids.
Minors are adults.
They're all adults, okay. One son, the parents put him through medical school. He says, I don't want the house. I'll quit claim whatever. I'm never coming back. I might not even be in Georgia. I don't want anything to do with it. The other son is in the basement who will not even buy toilet tissue and will not work. And the father wants out. So we know the son is sitting there waiting to be bought out. How expensive could that cost? So it's only 2 siblings. One will probably quit claim it's over. And I don't know, mom didn't have a will when she died.
Because all 3 have an interest.
Yeah.
In the property itself.
Mhm.
I would encourage that. You said, when did she die?
Probably about 3 years ago.
Okay, so if your support is not an option. Also, I'll mention your support, you have to do it within 2 years of the passing of the spouse. So that's a limitation.
So if somebody died, we need to jump on it.
Yes,
Okay.
within 2 years, because if
Okay.
you miss that deadline, it's just really hard to be able to reap the value of that particular option. Well, at this point in time, he will need to do a full probate. And it may be
Full probate.
a full probate. It may be a matter of him partitioning and kind of forcing the son to like allow me to sell this property, or even to do, has he even tried evicting him?
I think his son got on his good side, I think, when he started to evict them, and he didn't evict them. And
He got soft.
yeah, he got soft.
Okay.
Yeah.
Yeah, that one is really, really.
But money would get him out there. So if he knew that he was gonna get a third of it.
Yeah.
Because at one time he told me I was selling to buy him out, and his dad's like, I'm not paying paying for your food, your toiletries, your lights. What do you mean buy you out? You know, I've been carrying you since your mom
I
died.
think Dad has a whole host of issues that he will need to address. But the estate matter is definitely one of them where he will need to either, you know, buy son out or.
That's in, no, it's in DeKalb
I
County.
was like, oh.
So what could that run? Because he called somebody, and they said $5,000.
Oh,
And
that's
he's-
just the retainer?
No.
Total?
Probate, yeah.
Okay.
So he should have taken that.
Well, I mean, that's a reasonable price,
Okay.
but he doesn't know what that person will encounter throughout the process.
Okay.
Yes, ma'am.
Clients that are doing estate planning with you, what do they need to bring to that appointment?
Well, an open mind for one. For two, a listening ear. I do actually send out an intake form for them to provide just a good bit of information when we first start, just so that I can get an idea of where your mind is. And during that conversation, it really is just a matter of engaging to see if we gel well, because not everyone will be, I won't be everybody's cup of tea, and I recognize that. So, you know, we try to get as much information as possible, but there is an intake form that asks certain questions, such as the name of your children and your contact information. It requests your assets that you currently have. And also it asks for you to identify anyone that you would like to serve as an agent. So like with your power of attorney, your healthcare directive, your HIPAA, and even anyone to serve as your personal representative for your estate or a trustee, depending on the route that you go.
Having a will prevents the state going through probate?
No, ma'am. Having a will, you would still need to go through probate. It just solidifies the wishes that you would like at the time of your passing. Because you want to think of a will as like a contract. It's a contract that you have and you sign and you execute it, saying this is what I want to happen to my things when I pass away. And you do have the right to change it at any time that you choose. However, upon your passing, that's it. Otherwise, if you don't have a will, the state has a plan for you. It may not necessarily be ideal, but it's a plan.
What's the price average to go through probate?
Oh gosh, it can vary.
Let's ask that question.
Oh, you did?
Yeah, it can vary. Because I mean, for me, with my clients, like it can start around 3,500 and it can go up. I have some clients that it's been in the thousands, depending on what needs to be done. Because each estate is so tremendously different, and we just don't know what we will encounter. I mean, like I've had to do evictions in estates, all sorts of things. So
having the will will help reduce those costs.
it provides guidance, because even though you have the will, you can have a family member that's unruly that challenges it. You can have a lot of different things that pop up throughout that process that just create additional challenges and more expenses for you.
Wouldn't a trust alleviate that though?
Pardon?
Having a trust?
Ideally, yes, provided that it's executed
the
and
will.
funded properly.
Mhm.
It identifies what is supposed to happen with your assets, yes.
So that's the highest form is a trust.
It's a more protective measure. I like to think of it that way, where it's not as public. Because even with probate now, you can go online and just look at people's business.
Due diligence.
Yeah.
That was the first part of my segment. I showed them the Georgia Probate Court's
Oh,
website.
gotcha, yes.
Yeah, so we kind of covered that a little bit.
My last question.
Sorry.
The client has, her mom's will is filed.
Mhm.
Okay. The other siblings have signed off on it, giving her executor, whatever, giving her permission for that.
Yes, ma'am.
That's been filed. Can she sell that property?
Well, provided that the court has issued letters, because they can sign off on it, but has the court issued letters to her?
Oh, did I say mom had a will and mom left the house to the
Well,
person that's executor?
no, but what I'm saying is we still have to go through the proper stages of the process to where once the petition is filed, whether it's with a will or without,
Mhm.
once the petition is filed,
Mhm.
all the parties receive notice
Mhm.
as required by law for the acknowledged service. The court does their publication, they go through the file, make sure all the heirs are identified. Then,
Can we do this within a 30-day listing or is this?
no. No.
Which
Absolutely. No, but once all of that process goes through, the court will then issue an order. Once the order is issued, then the person that is petitioning to be appointed as the executor will then have to either meet other requirements, whether it is getting a bond or other requirements that are necessary. Then they have to take an oath, and then the court will issue their letters, testamentary or letters of administration.
Even if they've already signed off.
Yes, ma'am. There are
So-
still statutory requirements.
So it's fruitless for them to do this.
It's not necessarily fruitless, it just creates
Easier
less,
path.
it cuts down on the time. Because if they didn't sign off on it, then the court would now have to send them the petition, and then the court would have to wait 30 days for them to either acknowledge, object, or do nothing.
You got your hands full.
Why is that? Put this on your.
That client,
Yes, yes, ma'am.
A living will, you have a living will, but then you have a regular will. Once you pass that living will, automatically cancels and it goes to the regular will, right?
Well, I think it's important to understand the difference between a living will and a last will and testament. A living will is more of a directive. It provides guidance as to what kind of treatment would I like in the event that I'm suffering from a condition where there is no return.
Okay.
However, a last will and testament is a document that gives instructions as to what you would like to happen to your belongings at the time of your passing. Then you have a trust, a revocable living trust, which is also an agreement where you have documented and transferred title ownership of certain assets to the trust. And the trustee is responsible for either making distributions or doing investing or what have you, whatever it is that you've directed in that trust document. So a living will more so speaks to decisions regarding treatment.
Okay, I see what you're saying. So you really have a trust will, because I'm trying to decide now what type of will I want to get. I want to be able to assign stuff where when my father passed, he had a will that in that will I was the executor of the state where he told me what he wanted to do. Right.
So that's
Last will and
last will and testament.
Okay, all right. Gotcha.
Does your office provide probate leads
Probate leads.
for investors?
I have clients that sometimes want to sell properties really quickly, and I'll literally just send them an email of the names that I have and let them decide whom it is that they would like to go to, because I can't guide them either way. It's at their discretion.
I've got a lot of investors do that same thing. They scan, I have had that same question. They scan the probate records and try to find, maybe an estate that, they don't want it, there's no emotional attachment maybe, and they just trying to get rid of it and everything else. You guys could probably spend an hour going through and asking personal questions with Tanika on everything, but I've got about 45 minutes left and I got.
Thank you for coming.
It's my pleasure.
So you have cards?
I do.
Okay, so maybe leave them or leave them at the last table, and then that way when they walk out, they can grab your card there.
Absolutely.
But invaluable to have someone from a real estate standpoint, a referral standpoint, when you're dealing with this to be able to just send someone who does this all the time and can answer questions and everything else. So.
But it's good fun. Thank you all so much.
Thank you.
Good, now that our heads are all hurting.
Right. So while we're talking about the estate stuff, I want to just show y'all a couple of the, we're another break, maybe? No?
You're good.
Okay. So there's an executor's deed that I've got in your file, and I wanted to, and I know she touched on the procedure on all that. From a title standpoint, I want to just kind of show y'all what we've got and how we handle this from a closing standpoint. So it's probably 1, 2, 3, 4, about 7 pages in. There's an executor's deed that I've got. There's an administrator's deed. I think I put a conservator's deed in there as well, which would be maybe where a guardian ad litem was appointed. But if you look at those deeds, you'll see right behind each one, there's the letters testamentary. And you had asked that question. We saw that on the probate. That's what we need from the probate court authorizing the executor to sell the property. That was back, I think, was it Sally and Peggy or what, on the thing we had on the probate? Whoever that was that, no, that was your deal on GSCCA, but there was another one on the probate court. Peggy Smith and Peggy McEachern. McEachern was the exec, yeah, they had letters testamentary. So this is what the deed looks like that you would convey at closing as the executor, right? So there's not a will. You can do an administration of an estate, and an administrator is appointed, right? So you pass away, it's called intestate. There's no will, and there is an administrator that's appointed, has the powers by the court to sell the property, and then they make disbursements and so forth. So I've put a copy in there. Letters of administration are attached with that, which allows that person to convey. I had a conservator's deed. Sometimes you're dealing with someone who's incapacitated. There might be of age, but they're, they're incapacitated or they're not of age, and a guardian has been appointed to make sure all that goes through probate court, and you attach all of the orders and everything else allowing that to be signed. But back to the practicality of your listing and a deceased person on title. One of the things, and I get calls from, especially a lot of times from investors and stuff, what, so-and-so's deceased and they're on title. My first question to them is, aside from, has the will been probated? Has there been an estate? Is there an estate that's been probated? Is how long ago did they pass? And so from a title standpoint, if someone has passed and it's been more than 3 years, we can do an affidavit of descent and we get quitclaim deeds from the heirs. And it just so happens that right behind, well, there's the year's support order, which I'll touch on, but the affidavit of descent is in your package. And so from a let's clear title and get this house sold standpoint, right? If they pass and it's been more than 3 years, we can insure the title if we get the affidavit signed, and then we get quitclaim deeds from everybody listed in the affidavit. So the thinking is, it's the affidavit says these are all the people who have a claim in the property, and then these are all the people who've released their claim in that property with a quitclaim deed. And so there's the affidavit in your folder. Right behind that is a quitclaim deed. The quitclaim deed is kind of in the deed presentation too, but if you look in the body of that quitclaim deed, we've got underlined in the middle there that so-and-so is releasing any interest they may have in the property as an heir of whoever, right? And so on the affidavit, you would list the spouse, if they're deceased, the children. Again, you get technical, kids take their parents' interest, and so they step up and take their parents' interest if one of the brothers or sisters. So if dad passed away, mom's alive, and there's 3 kids, and if the 3 kids, one of those kids is deceased and they have 2 kids, the 2 kids get the deceased person's interest, and then you've got the brothers. It's very complicated.
It
Okay.
doesn't automatically go to the other siblings.
It doesn't automatically go to the other siblings, no.
The deceased siblings' children.
Will step up and take that 1/3 interest
Okay.
of that sibling's interest. So so if you look in the deceased, there's 3 kind of sections here: name of husband and wife, name of each child, and then it would be name of each grandchild, which would be the deceased parent. You list the deceased parent in there. This is very technical and way too complicated for what this is. But the gist of this is, if they've passed and it's been more than 3 years, we might be able to alleviate probate. And that's the bottom line, right? Not having
If
to
it's less
go.
than 3 years or more than 3 years.
It's more than 3 years. I might have said that. If it's been more than 3 years, then we can insure title with an affidavit of descent. and quitclaim deeds from the heirs. And usually what that means is everybody, all those heirs say, where's the
Give me
money?
some.
Yeah. Right, and then you're dealing with that whole.
Even if they've already signed this.
No. So let me back up. The affidavit of descent is signed by we usually get two, and one of them is a disinterested party that knows the family. And then you can have one who is a family member as well. So somebody signs the affidavit to list the heirs. And then you have quitclaim deeds from all the heirs. If we just filed 5 quitclaim deeds, you wouldn't know if you needed 6 or you needed 4, or so you have the affidavit to tell you who needs to sign it, and then you get the quitclaim deeds to make sure you have the check and balance of these are all the people we needed to sign in order to release the interest of the property. But it is a lifesaver from a standpoint of a contract and a closing if that person's been deceased more than 3 years to get your deal closed. We run into that a lot when dad passed away in 2000 and mom just stayed in the house. And then now mom's passed away and it wasn't joint tenants. And so we have to divest dad's estate, right? And because it wasn't joint tenants and they never did anything. They just always thought, well, dad died and he gave it to mom and mom lived there and now mom's deceased, right? So we see that a lot. We still clear that up from that. Mary, did you have a question?
Yeah, so it also has the affidavit of descent.
Yes, ma'am.
Also has to be signed by a disinterested party.
The title companies like to have 2 affidavits, right? Same information on the affidavit, but it's, it's like the brother who's dead in Florida or they didn't have a brother and, it could be very self-serving, right? So if I'm the only owner and I sign an affidavit and says, no, it's just me, right? And then I sign the quitclaim deed and I take the money and then the other brother comes back and says, what happened, right? So you don't want it to be a self-serving affidavit, and that's why you try to get, maybe somebody from the church that knew the family for 20 or 30 years, somebody who, a neighbor, so you try to get someone who is a disinterested party to sign that as well. And then maybe a family member, a spouse or somebody, or, but you wouldn't want the only person. And I had this one time and it was an attorney that did it. And he kind of argued with me. And I said, you got the person who's getting the money and selling the property, signing the affidavit. I said, that too many things can happen there. It's too self-serving, right? And it just doesn't work. But from your standpoint, from a listing standpoint, hey, so-and-so's deceased. Well, is there an estate? Was anything probated? Is there a will? And even if there is a will, right? And it hasn't, you don't have to probate the will. We could still go with the affidavit of descent after a 3-year period. So it's and I hate to say it, but it's a very useful thing from a practical standpoint of trying to close, your transaction when someone is deceased. So, hey, is there a will? Has it been probated? Is there an estate issue? And then the second question is, when did they pass? And everything else. Yes, ma'am.
I've heard that there's along with this, or maybe in lieu of this, there's like a hostile way to take it. If some family member that has been paying the taxes and maintaining the property and it's been over 3 years.
So maybe like an adverse possession type thing.
Yeah,
But you're going to have an estate issue. You're going to have quitclaim deeds.
So you still have to get all that.
It would be very difficult to say
Okay.
that, I paid the taxes and I've lived there, you might
I've heard
get-
that threatened, that's why.
It may be,
Yeah.
and
okay.
but maybe they get more of an interest when they go to divvy the money because they're getting reimbursed for the money they spent. But you're
But
not
they
going
still
to
have-
alleviate getting signatures from other people
Okay.
from all that. Yes, ma'am.
So there's an executive, you have an executive in place
Okay.
who are going to issue out everything based on either a will or their decision,
Well, based on the will,
based on a will. If there isn't a will,
then you do an administration and there's an administrator's deed in there and you're appointed an administrator of the estate. It's kind of the same thing, but the court has appointed you as administrator. Are we 12 or 12:30?
Okay.
Okay.
if
I'm
someone,
just observing.
Okay.
Actually, I didn't get one in your packet because I'm listening to you about my phone.
If there is someone who feels like they're being,
Sorry.
if there's a family member that's feel like they're being excluded from any of this, right? Do they go and submit this?
No, this affidavit, and I don't mean to confuse you, I just wanted to give this to you as an example. This is what we use when someone has passed and it's been more than 3 years to be able to close and clear title and get this to the table without having to go through that whole probate process.
If an investor wanted to buy a property or something like that.
Anybody, I mean, you got a closing and you got 30 days and Tanika just said, ain't no way you're getting it done in 30 days, right? You know, and you don't have letters issued. There's not letters testamentary. There's not letters of administration.
But that's the ideal situation. Somebody dies, you get the letters,
It is.
then listed. But
Yes,
you can't list it until you got the letters unless some of this other craziness occurs.
that's right.
Okay, so letters.
You
Throw me
want to
out
have,
the letters.
yeah, you want to have,
I
right, from
want
your
to
standpoint,
everything else unless
you don't
the
want to
letters.
waste your time. Because what if they dispute it and this person was appointed executor and then they say that person's a crook, you know, and then you got this whole fight about who's going to be appointed executor. Once you get the letters testamentary, the court, everything's been heard and the court has appointed that person to convey. Letters of testamentary, a letter of administration, that's what you want to have your seller sign that contract. Again, it would be the estate of Peggy Smith, and then so-and-so McEachern as administrator, as executor, anything like that. That answer your question on?
Yeah, but when you get ready to send out those quick claims to each of these people listed,
Right.
one of them have an issue.
Yeah, it's usually, the issue is money. Right?
Yeah, okay.
They're gonna want more money than the other. I mean, that's what it always boils down to. But if they're listed on that affidavit, then they're there, and then they sign that quitclaim deed, and we've had it where it's been a mess, and we've had 10 of these quitclaim deeds, because somebody died, and then they had 4 children, and I mean, it can be a real mess, but it's still quicker than going through probate. As soon as you can get everybody together, and sign and everything else, and everybody wants their percentage, and we listed on the HUD, 10 different checks to everybody. I mean, it's crazy. There was right before that affidavit was a year's support. I think Tanika talked about that. That's what the order looks like. And it's basically where the order that I have in there, James Marvin Mitchell passed away, and then Diane Marie Mitchell got title by year's support. And so that's going through probate court. If your seller has passed away within 3 years, you're going to probate court. If it's been after 3, that's just a good way to look at it. Which route you take, when you're in probate court would be something for the probate attorney to advise you on. But if, as a listing agent, if you keep in mind, if it's been less than 3 years, we're going to probate court. Hopefully they've already done it. Hopefully they've already been to probate court. But
Other benefits that year support have, because I have buyers who the spouse have recently passed away, so.
you get an exemption for the taxes for that year, your property
Oh,
taxes.
okay.
All of it or percentage?
I believe all of it.
Okay.
I think it's all of it.
Oh,
Yeah.
wow.
I mean, but you're still having to go to probate. You're not alleviating the notice, the filing of the probate, everything else. So, if it's less than 3 years, hopefully they have letters issued, letters of administration. There's a no administration necessary. There's different avenues which you can take in probate court, right? And that's someone like Tanika could advise you, this is gonna be the easiest, quickest, whatever. And then if it's after 3 years, we can rely on an affidavit and quitclaim deeds. And that's gonna be easier for y'all when nothing's been probated or done. We've had closings and we're waiting, and they go get a no administration necessary, or waiting on the letters to be issued. And they didn't realize they listed the house, and the agents didn't ask ask the one more question, right? And get that information.
So I'm confused now, because I'm saying, if a woman files a will and saying that she wants this oldest sibling to get the house, because that's the one that's.
Who filed the will? She made a will. She
She
didn't
made a
file
will.
it. You don't file it. Somebody doesn't file it till you pass away. They go file
Okay.
your, so there's not, like, if you had a will, it wouldn't be filed in the court.
If her oldest sibling filed the will,
Mhm.
You're saying the other sibling can still contest that, or they gotta sign this
Oh, sure.
affidavit before?
Yeah,
So-
So the affidavit, after 3 years, no, every, filing a will, okay, you're not gonna have the affidavit, and I hope I'm not confusing you too much on this affidavit thing, but can they contest the will? Yes, they can contest the will. So if the will says this daughter gets everything, right, you can contest the validity of the will. Was it just changed, and are they a sound mind? There's a bunch of different ways that you can contest that will, right? And then, the probate court would listen to all that. Sometimes they contest the executor that's appointed, because that executor might be old now and senile. Maybe the executor is deceased, that was listed in the will, and they appoint a successor executor. So there is a back and forth in probate court, and certainly could be contested. Doesn't mean it's gonna be valid and enforceable, the contest. It might still be that that's where the property goes, but they can certainly contest it. So, but the affidavit really is, from a title standpoint, after 3 years, that's what we rely on and can close. If there's been no probate done, no administration done, nothing's gone through probate court, we can use that affidavit and quitclaim deed. The year support order is just another example of what you can do in probate court, right? So year support, no will, you do an administration of the estate. There's a will, you administer the will, you probate the will, you get letters appointed to you as letters testamentary as the executor, and then you can convey. From your perspective as the listing agent, ask the questions. You want to see the documents. You can use the due diligence on the Georgia probate thing. And when was the date of death, right? So we're going to need a copy of the death certificate, right? You might as well blame it on the attorney. The attorney's going to need that death certificate. You might as well go ahead and send it to them, kind of like the operating agreement and that stuff. Yes, Mary.
It's just, if somebody has made a petition, you probably want to wait and see how that goes before actually trying to sell the property.
Yeah, if they've already filed for probate and everything. Yeah.
And is there anybody else besides the spouse that could file for years?
I don't believe so. I believe it's only the spouse. It's an each question, but I don't think that.
Because they have they were.
But I have seen it go to children. So, but I don't know if the children could file. I bet you a child could file that. Because I've seen it where a mother and a child got that property. So
it's basically in limbo with that year support, and you're waiting for probate and all that, so you're probably not, as real agents, we're not gonna try to sell it yet. Or we could, with given all the other due diligence stuff. But what does this mean in terms of selling? Or
right. So if there is a year, if anything has been issued by the probate court, let's try to simplify. If anything's been issued by the probate court, you want to see it, and whoever's been issued that, that's probably going to be who your seller is going to be, right? For the estate. So a year support order is something that they would say, oh, I went to court and I got a year support. Let me take a look at it. Send it to me. Let me take a look at it. I've got letters testamentary. Oh, great. Let me have that. You're going to be signing. You didn't have a will, but we did administration of the estate. Great. You got letters of administration. Let me have it. So anything that they have done in probate court that they say, oh, no, we've probated the estate, right? Then you want a copy of that, right? No, we haven't probated the estate. He didn't have a will. When did he pass? Passed in, 2015. And in the back of your mind, you say, great. Because it's been more than 3 years and we can do an affidavit and we can do quitclaim deeds, right? And then you go ahead and you list that, you start to list that out. So maybe the next question would be, who do I put on the contract, right? If I've got you could still do the estate of whoever was on title, right? And have, it can get a little tricky, but if you know who the heirs are, you can have them sign that because it's more than 3 years. It's probably something you're going to need to email us or whoever you're working with just to kind of get that information. But it's
somewhere in our contract when it talks about conditions, it says something about title is not in seller's name. So we need to check that box.
Well, the estate is selling the property. So, and we're just divesting the estate in order to be able to ensure title and convey it to the buyer. So that example goes to my D for dumb, and that's the wholesalers and the signers who don't own the property, who are trying to turn around and flip it and sell it.
That's our next section,
Can we
right?
go to
Yeah.
the-
Yeah.
Can we go through that one since we're almost right now?
I know.
There's a lot of wholesalers right
Pretty soon
now.
I'm gonna be. All right, and that's like that's like real estate of the soup du jour, right? Real estate du jour. I mean, that's everybody, and I don't know if y'all see that, if you have listings and you get the what I like to call the bird doggers that try to get them and you know, whatever, flip them and everything else. And that kind of brings me to the dumb side of things. But I do want to, if you look from after that quitclaim deed, I put a resolution in there. So let's kind of go to the investors, companies, assigners, and all of that information. And so this is a blank resolution that you could really use if you needed to, because you could just fill in the information. A resolution, we have an LLC, and an LLC is governed by the operating agreement, right? And that's the thing, blame it on the attorney, let me see the operating agreement. You not have a resolution? You got it?
How does it look?
Just a one page. It's very, very simple. And what you're stating in that resolution is this person's authorized to sign to sell this property. And they're gonna sign as the manager, or they're gonna sign as authorized signer, or they're gonna sign, you're giving them the authority. And the members of the LLC will sign the resolution. So you can be a manager of the LLC and not own it. The membership in the LLC are the owners, the members own it. Like a company and a corporation has stockholders. So the stockholders own the corporation, right? And the LLC is owned by the members. So you could have 4 members who lived in California who bought and sold property, right? And they could designate you as the agent, as their manager. And you could sign documents on their behalf. They would then sign a resolution that says, this is who's gonna sign. A lot of, most closing attorneys want a resolution when you go to do a, you know, from your seller, so that they know who's signing, what the authority is, who, you know, are they the manager, are they the member? You know, and so they'll want a resolution. They're gonna want the operating agreement because they're gonna wanna see how that is set up. Is it just one person as a member? There are 4 members, you know. The good thing about an LLC is it's not filed with the Secretary of State from the operating agreement's not filed with the Secretary of State. So you would pull the Secretary of State up, you'd see that it's active, but you have, you know, you can be kind of anonymous in that sense, because it's only in the operating agreement which shows who the members are, and that's not public record. And you can have John Doe be the manager and he goes signs everything, and you can be in California and really nobody knows that that's, you know, the attorney's going to see your operating agreement and know who the members are. But we rely on the operating agreement to determine how the property, how the LLC is managed and who's the ownership and what authority does a manager have? What is it member managed? I mean, there's just a lot of different variables there. Back to the reality of you doing a listing and having an LLC and signing and everything else. I think it's your best bet is to go on Secretary of State, make sure it's, you know, not the trucking and it's the capital and it's an ampersand or an and you list it like that. And you know, we're going to need a resolution. You don't need to worry about that. That's something that the closing attorney is going to do. We're going to look at the operating agreement and we're going to make sure that those people have the authority to sign. I think a good trick would be to go on GSCCA and look at that LLC and see if they've sold something, and look and see on the signature line who signed it, because more than likely the attorney who did that closing got all of that information, right? So if it says John Doe as manager on a deed from last year, and you're dealing with John Doe and you got that LLC, you're pretty confident that John Doe's your guy. He's the manager. He's been conveying property like that before.
How do
So-
you connect the dots?
with GSCCA, remember, I got the first $12 monthly. If y'all have closing, you have mine, I'm paying $12. But you would just look at an old deed. So with Dennis Luck, right? Yeah, and you look at the signature page where they sold something, and it's a great way to see who's doing the work, who's selling this stuff, who's conveying this.
Open
Right.
Door, they do a lot of that. I do a lot of buyers with Open Door, and they're like that.
Yeah, but that's a whole nother ballgame, because they got different LLCs.
Yeah, but you can tell us that they have the thing that
Yes.
person has the right to sign off on.
That's right, that's right. So, but I think if you know, your LLC is registered and you're dealing with somebody, I think you're gonna be okay. Having them sign that contract. If you were questioning that, you can always get the operating agreement. Again, we're gonna need a resolution by the time we close and everything else. A corporation, this is a resolution for an LLC, same thing for a corporation. The resolution just states, this is who's signing on behalf of the company for this, selling this property. You know, could be, if it's a company, it could be a president, vice president, the secretary. This would lay out who's signing the property that's being sold and the capacity. John Doe is president, authorized to sign, right? And you would have the officers of the company sign this. So most of the time, you're going to be dealing with LLCs. Right? It seems to me that that's mostly what we run into from a title standpoint. You know, sometimes they're a Delaware LLC or a Wyoming LLC. You know, but we can determine all that. You can ask them just like anything else. Hey, send me all your corporate stuff because the attorney's going to need it. And that way you got it. You can take a look at it and make sure you're not dealing with somebody you're not supposed to. All right. Assigners, wholesalers. Boy, we could spend the whole day on that. So I'm curious because we deal with a ton of wholesalers and assigners and investors and a lot of the, like we buy ugly houses, guys that probably buy stuff from y'all if you have your listings and everything else. But just feedback wise, are y'all getting a ton of investors, these guys that are, you know, submitting offers and then doing the due diligence and then canceling and yeah, and the offer looks good and they got 2 days, they run out there and they say never mind and everything else. Yeah. So that kind of goes to my dumb thing because a lot of times we're dealing with assigners who someone asked about the probate stuff and they're going through probate and they're, you know, I mean, what I view as, you know, an unlicensed real estate agent. They're getting a fee for selling that, you know, but they are, the buyer's paying them for that service of getting, you know, getting that property. And sometimes they're involved in the transaction as far as ownership and sometimes they're not. But, you know, from a paperwork standpoint in your package, I don't have, there's not a lot to that. I'm happy to answer questions on the wholesaler and assigner stuff. But it comes back to the LLC. Most of these guys don't know their own company. A lot of times they don't have a bank account in their company. You know, I feel like there's just a lot of uneducated folks doing this stuff. And it's like they went to the Holiday Inn on a seminar for the weekend, you know, and it just is, it's frustrating.
It sounded simple.
Yeah, well, it's like buying tax deeds, and I've seen stuff on people buying tax deeds, and, you know, then I get a contract, and they're ready to sell that property, and they got a tax deed, and that doesn't, you know, that's probably a good point. You know, if you ever get that, and there's a tax deed, and you say to your seller, hey, let me see the deed, obviously, good, right? You gotta have that question, and it's a tax deed, red flag, right? Because you have to have quiet title. There's a process that has to go through. A tax deed is not insurable title. And so, you know, I would tell you, if it's not a warranty deed or kind of a quick claim deed, you know, then you spotted the problem. You don't need to solve it, but you spotted there might be a problem there and at least need to ask a question or send it to somebody who can take a look at it. You
I got
know?
a question on that. So I buy at the tax lien auctions. And I often get investors that are sending like little mailers, like, let me buy your property, but obviously I don't have the quiet title takes over a year.
Right.
So.
They can buy your interest.
Okay, just buy my interest.
Yeah, you do a quick claim deed,
you transfer your interest to them. They can go do the process, or they can, I mean, they're taking the risk. Right?
Yeah.
Doing that. But that's not uncommon. But I just feel like a lot of this wholesaler and assigner stuff, you know, we do a lot of closings where, you know, it's being bought and sold in the same day. They're wiring funds in, they're closing on that, paying cash, and there's another person paying cash right after that. You know, it's just,
It's very popular right
it's
now.
very, very popular. A lot of people, everybody's in real estate, so.
Yeah.
Yeah.
In regards to that, could you speak to the Form 22B with the investors as well?
On the GAR form,
I guess it's like, it's a say interest, I guess, transfer.
Assignment.
Assignment, yes, assignment deed it's an assignment on deed.
So.
And then, but.
What
yeah.
we'll get on our contracts is a contract, and then we'll get an assignment contract, which is a one-page kind of contract. So they might have in your GAR contract, if you've got the listing, right? The right to assign it as the buyer. They've, you know, unfortunately, your seller's at the mercy of whoever this end buyer is.
That's
right. And we end up getting it's a cash, you know, addendum, and then they're using hard money, and then they want to close Friday, and then we do a HUD, and then the investor says, "Man, I'm using hard money for this," right? And so now it's gone, even though they treat that as cash, they could lose their earnest money because they did it as cash. Now it's a lot more work. Now we're dealing with a hard money lender. They're charging them 14%, charging them 4 points. You know, I mean, it's just the whole thing. But the assigner, you know, is basically to lay out the structure. If the purchase price is $100,000 and there's an assigner and he's assigning it to someone for 10, right? We're still showing a sales price of 100,000, and that buyer's just paying that person 10,000, right? It doesn't affect your seller at all. The only problem is, from your seller standpoint, is they're not dealing with who they thought they were dealing with, and if they got a cash addendum on that, you know, it might be hard money. It might be, you know, they're trying to sell it to somebody else, and your poor seller is thinking, well, I'm dealing with John Doe who's paying cash, and we're closing Friday, you know. And I just think it's very frustrating as a listing agent and as a seller to be in that, you know, process and thinking you're going to get X on Friday, and it ain't happening because everybody's got their hand out trying to, you know, and from our standpoint, the practical standpoint, you know, these assigners have no skin in the game, and they wear us out, and they're getting $1,000 or they're getting $2,000, and they just sometimes, yeah, but I mean, it just, you got no skin in it, and they're just turning to the next guy, and we need the end guy, right?
How dangerous is that to the seller, though? If they
Well, no, it's not. The seller has agreed to sell it for 100, right?
Yeah, but they also assign the deed so that middle.
No, that's, I wouldn't think the seller assigned it.
No? Okay.
They wouldn't sign any deed.
Okay.
I mean, there's a lot of creative stuff out there, but they wouldn't, if you represented a seller, right? And you had a contract and they sent you something that said, we're assigning this to so-and-so. You probably wouldn't even see the assignment. Right? You just know that your new buyer is not your original buyer. And there's a separate agreement between the guy that you did the contract with and this end buyer now, where he's going to pay him $5,000. And so it's just from us, you know, and you know, it's gonna run its course, right? And this will go, you know, back when things were bad, it was all short sales, right? Everybody was doing short sales, and now it's just, you know, it just kind of, you know, it'll run its course and everything will kind of settle down. But for right now, a lot of these folks are, you know, off-market properties. And they're trying, and you wouldn't see that from your standpoint, but there's a lot of folks that are working on trying to get
mobile homes.
Yeah, no, thank you.
Yeah, yeah. So I included, so on the tax assessor site on Q Public, a lot of times you will see in there where it's a manufactured house. It'll give you the information, like it'll give you the manufacturer or the year. So mobile home, and you pull, and I don't know if you drove out there, you might not realize it if it's, you know, there's some manufactured housing that have gotten FHA loans and they're good to go.
But if you see on the tax assessor, that's where you're really gonna find that, if there's a mobile home, the title has to be retired in order for it to be, or there to be financed. Okay, and so at the very end of your package, I put a T-234, and that's what's filed at the courthouse, right? And I don't mean to make fun of it, but it is kind of funny to me, and I want to show you that on that T-234, the very last. Yeah, so it's right before the deeds. So it's probably the last two pages. These are recorded, so this is what actually gets recorded to do the title. Y'all see the very last, to the very end, and about 2 pages it back up. You'll see the T-234. That's what gets recorded. You wouldn't, the question you need to ask if you're taking a listen to this mobile home is the title been retired, right? Send it, you can look for it on GSCCA, but you want to make sure the title's been retired. It doesn't have to be retired. You're just going to be selling it for cash.
What does that mean?
So,
Retired.
yeah, so a mobile home has a vehicle title, right? And technically you could get a sticker and a decal, just like a vehicle. And in order for it to be affixed and be, the title has to be retired you send it to the courthouse, they send it to the tax commissioner, and this T-234 is filed. Okay, now you get a lot of times where you get someone paying cash and they don't care, right? And that's fine. They can own the land, and we don't insure title to the mobile home. We insure title to the land. But if you have a listing and there is a manufactured home or mobile home, you want to make sure that the title's been retired. You don't want to spend your time dealing with that because a lender is not gonna lend on it. That's gonna be their requirement, is title retired.
But if it isn't, you can just list it as cash on.
Yeah, absolutely. Yeah, mobile home title not, I mean, if you put that in your list of requirements and you said, yeah, mobile home title not retired, cash on,
And this form is found on the Q public site.
The information on the taxes, a lot of times they'll have square footage and the year the house was built and everything else. This is gonna have the serial number and the model of the mobile home. It's not gonna have all that.
But so you're just buying the mobile home, you're not buying the land.
You're buying the land. You just don't have the title to the mobile home. And when you retire it, then it's all one. A lot of times on the tax assessor, it'll all be taxed as one, right? And so that gives you a little more comfort that the county's taxing the property, they have improvements on it, it's all being taxed as one, but legally the title's not retired. And so my joke on this kind of is, if you guys look on number 6 down there, it gives the VIN number, right? So it's Georgia, it looks like Florida.
Yeah.
And then it's 675, and there's A, and then there's B. You know why that is? It's a double Y. Got an A and a B. On the VIN number. It's on the VIN number.
2 separate pages.
Yeah. The VIN numbers are 2 VIN numbers because it's each side of the double Y. One side A, one side B. So,
Wow.
I have a question.
sure.
I'm sorry, I was just about to say, that means this one is not retired.
No, ma'am. That document there shows that it's retired. It's filed at the courthouse. You're good. You're good. You can, listing wise, you don't realize the mobile home is your title retired. I don't know. I mean, email it. We'll look at it. We can find it on GSCCA pretty quick.
This PDF copy is also on a text.
It is
I
not.
have an issue right now with this.
I know, I've had more mobile home crap
I have,
lately
and
than.
the appraisers went out and they can't even determine.
Yeah, you gotta get it. You have to get a title. I mean, that whole process is, you gotta get law enforcement out there. They gotta read the VIN number. You gotta get a title bond. You gotta get a replacement title. You have to send it to the courthouse. It is a mess. Yeah, it is a mess.
I was gonna ask about that. I have somebody that wants to sell his mobile home.
Yeah.
It's on the Center Park, right?
Yeah.
He paid it off 6 months ago.
Yeah.
But the park doesn't want to give him the title. So he's waiting for this title.
Yeah.
And he doesn't know what to do. He goes every week.
Yeah.
And every week they give him an excuse.
Yeah, they probably don't have it.
So what can he do?
Right? They probably don't need to have, they need to get a replacement title. Just like you lost your title to the car. That's probably what it is.
So the park needs to get everything.
If the park owned it and he bought it from the park,
Yeah.
just like buying a car, right? You bought it off the lot,
They owe you title.
they owe you the title. That's right. On a closing like that, we would do a bill of sale for the mobile home if the title's not retired. So cash closing, you know, we conveyed the deed with the 5 acres and they do a bill of sale for the mobile home. So the last 2 things on there were some deeds, limited warranty deed, everything in the contracts that y'all have, guard contracts are limited warranty deeds. And then there's a warranty deed. And I underlined and the difference. A limited warranty deed, you're only warranting, this is just good general knowledge, not so much from a contract standpoint. Limited warranty deed, you're just limiting your warranty from when you own the property going forward. And that was the joke I made about HUD being a special, limited, same thing. But I underlined down there the distinction where it shows that it is just through the grantor. And then there is a warranty deed, which is through whomever. Also on the warranty deed, you'll see the joint tenancy language. So that warranty deed, the very last document has the joint tenancy language. All right, I got a 1 o'clock closing. Any more questions? We could talk all day on this stuff, but.
Great class.
All right, so two things. One, I'm in Destin tomorrow. 2, if you're in my office and you've got GCSCA, come up and say, Bill, you owe me $12. I got your first month.
Let me know if you see something for sale in Destin.
Yeah, it is outrageous.
I know it's so high.
It's through the roof. Oh, my goodness. All right, thank you all.
Thank you.
Appreciate it.
So much.
My card's in there, and if you have questions, yeah, shoot me, email's the best way. You can email me and I can at least answer you when it's not quite so crazy and everything else.
So we give this back to you and we sign off.
Yes. Yeah.
Yeah,
y'all don't forget to initial off, we'll give you a survey just to see what you think about our instructor here.
Before, after he get back there.
I'm back Sunday. It's okay. Quick trip. Actually, my girls are in school and that's our Mother's Day down there because I got one in Florida and I got one in Texas. And so we're meeting down there. That's our Mother's Day because they had exams last week and couldn't come home for Mother's Day. So that's kind of that's the deal there.
I think I was deep sea fishing years ago. Oh, it was
Yeah.
heaven.
All right. Y'all have a great day.
Thank you.
Email me if you have any questions. Happy to answer whatever I can.
Appreciate it.
All right, absolutely.
I'm sorry. I'm welcome.
She has a video on the library on the stage to get a bus.
You know how he said go on to the tax assessors and check on your family
Yeah,
and
I
your
can't
friends and
remember.
stuff. You know, I've done all that. Everybody I know,
My son is there, that was the assignment.
just to learn how to use it.
And, haven't done it.
Okay. He's so full of information. He really needs to learn.
Right. And the actual salary only every month. Right. Right.
Thank you, everybody, for coming out to the C class, and I'm going to shoot Adrian, my sign-in sheet and get all your hours recorded. They should go in today.
Thank you so much.
I don't know how to spell. That was so good.
That was great to see the participation.
If you've already got them signatures, see, I'm dealing with that too. My mom passed away in
Oh, you know, the
18.
Georgia
Her
real.
will, it went to all 4 siblings, okay? So, will was
They all
filed,
got copies.
Yes, and then I probated it because my grandmother, who passed away 3 months after my mother, was the executor. And she was 93 when she passed away. We elected me as the executor, probating the will, everything. I want to buy the home. I want to be in that home.
.com.
Well, so my sister says,
Okay.
no, my sister says,
Okay. It's all women. I think it's like 10,000 or
yes.
20,000.
My other brother.
Oh, wow.
I got one. I need one.
That's a lot better.
Her house was worth about 180. Well, now level of taxes, that's worth about.
And then,
So when my mom passed.
Stacy
we
Rossetti
said, Virgo,
has.
if any sibling wants to buy, let's sell 55 grand. So you buy, you know.
If you wanna get.
Got Atlanta real.
55 grand. It's a big thing. There is no mortgage.
Okay.
But it's on 3 acres and all. So we all agree that I'm the one that should be there. But my one brother,
That's a Pandora next.
that is, he's passed, he now wants me to pay him 80 or 90. Or
He used to be called
start paying
Atlanta
rent. I pay the taxes, I pay the insurance. I'm not paying rent. Do you see my house?
Kind of what, I was interested in doing some of that stuff, but I wanted to get a little more training, it's a little riskier.
The will's
than what
done,
I'm used to.
probated, I'm executor.
So I wanted to-
My brother says, I'm gonna petition you to buy me out. I said, you don't have to petition me. I'm gonna buy you out. Nobody. I'm not in a position right now.
She got one of the better ones. It's like the Georgia Red is more of an older crowd.
Oh, okay.
His
Stacy Rossetti.
one son, one biological son, my nephew. Yeah, he
And
wants
then
like,
the
we actually have 6
Atlanta readers,
acres.
what do you know about that?
3 are
I
titled
think
to
everybody,
the house,
each
and
one
3
kind of
are.
focus on different things, but they have classes, so you can go on their website and see what type of
My
classes
nephew
they
wants to be
have.
in this. I don't really want him to.
Let's see,
It's getting, it's.
I thought I was coming here.
That's why I sat in here.
I thought I was coming here. So you should be getting a.
But it's because I-
every time they go to. So I have-
It's been like Mine and his.
because Stacy mainly focuses on,
Because if we, you should be getting. I got one.
self-storage.
What is it?
Oh, so you get.
Self-storage.
Oh, okay.
So you
I
know.
know, so that is working.
Okay, that's fine.
You saw Malvern.
REIUSA.
Yes.
Because it's called real estate investments. It's with REIUSA.
Cause I have some friends, they actually, they buy property, and they. And then they end up renovating and the county or indigent or.
Oh, yeah. Just guaranteed money every month.
Yeah.
You should tell them that you want 100% integration, you want to be part of the deal. You can sit on 5%. Yeah. Actually, it's a deal.
That's kind of my one.
But in these meetings,
I
like,
think
I want someone at the door. You can go as a guest, you don't have to actually sign up. You can just go as a guest. But they have non-member prices. So you can go to each one to see.
Which one might be a better.
Yes.
What I want, yeah, that's what I was doing.
Cause I met some private lenders there and I'm like, wow, this is interesting. They don't just walk with you and say I'm a private lender.
Right.
You gotta kind of just engage and talk and,
Yeah.
you know, and it's a guy named Frank there. Frank was like, he introduced me to his private lender and the guy was like, hey, this is my situation, I'm borrowing money. And he was like, give me your information. I'm like, wow, just that easy.
I think my neighbor, I have a neighbor who does that. He must be doing really well. He, they all have BMWs.
And most people be looking for money to deploy and they just need somewhere to put it.
Yeah.
Okay. So you gotta present a deal, honestly. Yeah. You got something, because if you wanted to get in the hotel and just say you need 50,000, you can just present that, hey, this is how you're gonna pay your house.
Okay.
Thank you.
They see you have a. Oh, I'm going through it and Alan had told me I need to talk to him and get my problem figured out. But that was first I heard about the 3 years.
Yeah, the bonds is about, but I think it's better if it's over 3 years.
He said that.
That's good. We got something in our favor.
Yes, but like I said, I've already done probate.
Over here.
I ain't doing it. Cause I figured it was.
Yeah, see, that's why I'm afraid for mine, because mom and dad's house paid for it. It was built up.
There's no.
But I had to stop.
How do you make this? How do you put this on that? Did you send you to the state?
No. And the
How
house
do you
didn't
do
turn
it?
I said, I want to.
Up there. It's not like here. Who's putting
And they don't have
the
keys. They had keys, but
Oh,
I
we can
changed
do
the
it.
deal.
So
So
only
it's,
here.
but they gotta keep that. So they don't have keys. And my hateful
Only
sister
here, you put
lost.
back these, and when you talk to him.
Changed my cousin, my brother. I'm like, don't come in my house. I live in here. Don't come in here. Yeah.
Well, I did sign.
If you want to come, when I'm here, call me, check on me, make sure I do something, but don't come in my house. The stuff's in the house.
So look, I gotta take care of my clients. Make sounds that are.
Or we can.
That's why I have her. And she said, fine.
Oh, I got a headache now, that one. So we're gonna have to pray for each other.
It's like text right stuff she's going.
This is the rise of
Her daughter,
of the
goes to college.
This one you need to print.
Yeah, yes, yeah. That's just saying, it's no, the showing time for the inspection. It's on super, so. The water's up, but everything's going on.
You say, it says, where, that's when we use
The term days of reference.
see what he's saying, business day, so if you sign today,
Today, 0, tomorrow, is 1.
so 1, 2 is a business day, so 1, 2, 3, 4, 5, 6, 7 days, so you have to wait until the 20th. Or we say 5 days. 1, 2,
But not Saturday, right?
Saturday is.
That's a business day? Oh, okay.
It's not, it's business day.
Okay.
So we got 1, 2, 3, 4, 5, you have until Wednesday,
Right.
to wait, if they accept it, if they don't
Right.
accept it. And they said 16 days, 16 business days from the due diligence, that's what it said, right? From the due diligence ending due diligence. So if the due diligence ends on the 18th, that's when he's gonna start counting 16 business days. So 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16.
So what is it, wait, what is he saying, 16 for?
On the purchase and sale agreement, it's telling you that to close. This is it, 15 business days following the end of the inspection period, which is the due diligence. So after the 18, he's gonna start counting 15 days, so he wants to close on the 7th. Oh. You know what I mean? So it's easier to, he's giving you until the 18th to respond.
Yep.
So that's a lot of time.
Yeah.
He's giving you until,
Yeah,
he's giving you to the
Yeah.
18th. You can wait to see if we get any real agent.
right, yeah.
So this are something you make to, you have to make the decision. You risk it or you wait. You know what I mean?
Right. Wait to respond.
You have a few times for this, see if you can get more offers. You have a Facebook page?
I need to make a business one though.
So anyway, it's up to you. If you listed yesterday, today's the second day. I know they want to sell fast. Unless you run it through her because at the end it's her decision. Just explain to her the risks that we're dealing with an investor. You need to ask if he's willing to let go of the business days and just do regular days, especially for the due diligence. You can just talk to him and see how.
Yeah.
What he says, because if he says, oh, no, you have to be, then you know that you're gonna be waiting longer. And then run it through her. Is she willing to wait? Or take this off? And then he doesn't get back to you, let them make the decision. You know? It's so scary with this, because they pull out at the last minute. Like, Bill said, like, one way before.
It's just so scary, this whole market period,
I know.
because waiting for appraisal, this and that, it's like,
it's as is, so.
It's good that it's cash and they didn't know the appraisal doesn't
Right.
get it back.
Right. So I was looking at the property yesterday, and I'm like, you know, I'm always just skeptical about the roof. And then with the as is, so with the VA, that was fine, but I already know it's gonna be.
They're gonna find the appraisal. If you know it's not gonna be
Yes.
worth that amount.
Yeah, I already know, like 280 in that neighborhood, everything's like 260, whatever. I know that's already a lot, so you could say you offering that. I'm just trying to do this whole thing without the appraisal thing.
So if you're willing to work
All I
5
can do
days,
is see.
you can do 5 days. And leave it open, and then if you get another offer, you say, I'm taking it back up offers. You know what I mean? We don't put it on the contract yet until the 5th day.
Okay.
Even though sometimes I think last time she fined me because of that. I don't know. I don't know. Did you get to pay all the fees on the monthly office fees or no? Also when we close.
Yeah.
That's how you say that she waits, because it's been on. And you know you went out. No, you still have to pay it. Or you can change your membership, not membership. You can change your spirit, if you mean actively working or whatever, I change it to pay like 20%. You know, right now I want to 75, but I think it's a lower monthly payment.
It's 70, I just got.
70, yeah.
70.
But there's another one. You pay 70 because you pay only 300.
Right.
That's awesome. But if you know you're not gonna be actively working, then you pay a monthly. I don't know, she went up to it was like $27, but the time of the closing, I will pay like percentage, 7 to 300. But if you're back working, you must wait.
So I just want to go with this guy paid up, and then I could stay on top of it. This time I'm a little bit sure I stay to pay the
Well,
monthly.
we
but I
already
need to-
learned that going to work for a company is hard.
Yes,
Because you used to work for
exactly. Now I go to help my mom, get her to do something like that, you know, because I'm both age, I get paid. But I was to agency.
You can have your license with her. Yeah,
Not paid.
yeah. Just put it in active for now.
I didn't know. It's best.
So ask her, run it to her.
Okay.
Um,
After this, I don't have it to offer.
Or
Business like that.
But do you want it up business or you just wanna do your house?
Right now, I to focus on helping my mom. If something comes along, then fine.
But if you can, that's the thing, if something comes along and you're not actually paying your monthly fees, that means you don't, you just, I don't know if the word is inactive, but anyway, you just pause your license, so it's not like, oh, I got a deal, and then
Right.
you can just go ahead and do it, no, you have to activate it again, and pay your fee.
Right, exactly. For this company too, you can just still be active with the broker. But you just pay on so you don't have to be going in and out of active license still saying active, but you don't pay all the office dues and like that.
I think, that's what we have. We have
So
that
they have
option.
that option. That's probably what I want to do.
Yeah.
Without even maximum money.
That's what you
send it to me all the time, like. So,
But it's not to showing time, you see, these are investors, or maybe this is just, legal office, she's asking you if you
yeah, if
have a
there's
little
something-
like.
well, you know, when they say, oh.
Yeah, they said, no, you still have time to show it. The house is always eight.
Right.
And she's asking, she's expecting me really for price, because we do have
Right.
to cash out first.
Right.
And they said, okay, I'm gonna make the payment. Well, I was gonna make a payment, but now they're charging 3%.
I'm just like, you know, seems so cash.
Yeah, and you did.
So I want. Yeah, I think we need to put a, like, she's like freaking out with the sister having access, so I have to
Mm-hmm.
change that.
Oh, you know what? Thank you for reminding me, because I forget things, but, I have the same one that I'm changing, I'm gonna read the instructions,
Okay.
I'm gonna send you a picture.
Okay, I was
Okay.
trying to YouTube it to see.
Yeah, well, you can also do that, but,
What, yeah.
I put the same thing,
Oh, you did? Okay.
yeah.
Cause it's something, whole the thing I was trying last night, but it was getting dark and I hate driving in the dark and it was late, so I was like, so I was gonna have my husband to screw it and just maybe disable the part that's electronic, cause the key is still in the lockbox.
She doesn't want her to go back.
Right, she just doesn't want her to have access to go back in with the, cause she has the code for electronic.
How she's gonna get the stuff out?
She already got everything out.
From the garage?
Mhm.
From the
Yeah, she
garage?
did. That's why she left the back door
Open.
all open. She got all the stuff the other day and she just left it open in the back door. 'Cause-
I see.
So,
I take a picture of the instructions and send it to you.
Okay.
Show me again, make sure it's the same, I'm gonna take a picture. I think it's the same.
so I didn't have a screwdriver because there was nothing in there yesterday. So I have to go put that piece. I'm gonna go to the home to buy the piece to put on the back door to
It's
secure.
pretty stick, a
Yeah.
brown stick. Add it in. Make sure
Yeah,
it fits.
I do have a whole bunch, because that's what they had, but it
Uh-huh.
needs to be, I found one, but it needs to be cut, so I don't have a saw thing to cut it and whatever, so. I don't know.
Well, you know what you can use maybe? Curtain, shower curtain because it goes up and down. To get the cheap one, then you
Okay.
can just extend more.
Something, those I put in.
That's in
Yeah,
here.
go on the other side. I was like, trying to list, because I have one on my door, but it's through like ADT. So I could just take the batteries and then the thing won't work, but I don't know. on the other side of
And you,
this.
and you know that code?
Yeah, she gave